Store, Dr. Deb Shard.
Debbie Pashard.
Um,
She'll slaughter it about 4 more times today,
Well,
so
who?
don't you worry. Just call him Dr. D.
I call him Doc, because I'm not gonna call him Kevin, and that last name's got way too many vowels in it.
Yeah.
I didn't get my vowels, and so I'm not real good about it. But Kevin kind of throws me too sometimes, but I'm learning with him, because he'll teach you.
Yeah.
Also Miguel Delgado, which we appreciate, and always Glenda Lee. Thank you very much, you guys. We couldn't do this without you. The way these girls put these things together is amazing, and I really appreciate it. Our industry is better because of you guys. Yes,
And
Lois?
you've got the backup dancers.
Yeah, the backup dancers, yes, it's true. We do have backup dancers, and that would be you, Delora, and that would be Laura. Yes, it's
And
true.
Cody,
And who? And Cody. Yeah, we love Cody. That's true. We do. We absolutely do. And Mike. Oh, okay. Okay. Yeah, we definitely. It's a group effort. We appreciate them all. They're amazing. Don't forget to go to our website, check out the future events and dates. They should be updated by the end of February. So you have to say this might be need to update.
Oh, yeah,
Okay.
okay. I forgot to take that one.
Okay, I'm all good.
Sorry.
We're working on the whole membership thing. Thank you. We'd appreciate it if you joined your membership. Your membership is for the day you joined for 1 year, but we really want you to have more benefits as a result of that, so we're working on it. Right now, we use that money to basically do stuff like this. I gotta say thanks to Sandy in the Las Vegas Water District. Amazing. I wish, this is incredible. And we are so appreciative because the one thing we don't want to do is spend $2,000 every other month for an event. And we greatly appreciate it. Thank you. Capital Vote also pitched in, and we appreciate that, as did Las Vegas Neurosurgery and Spine, which is Phalangus and Dr. Jong. We appreciate your guys' support. You really do help us out. Thank you very much. Already said open forum, ask anything you want.
If you do have a question online, just raise your hand on the icon, and then I'll open your mic up, and then you can ask your question.
Awesome. So today, we chose to be dynamic in our panel. And it's one of the reasons because we want all angles of this. One of the other things I wanted to say, can you see me?
Yep.
This book you can get on Amazon. I strongly recommend it. Now, it's a Benjamin. It is a Benjamin. It'll cost you $100. However, it is the AMA's Guide to Causation. So basically what it does is if you go, okay, so he fell on his face, but his ankle hurts. How's that work? It'll show you. You saw it. You saw the clinic. You know it. So I always, before you pick that phone up and challenge the physicians, I want you to look at this too. Do you want me to bring it to you, Jacob? I'll bring it to you. I want you to look at it.
I actually have a comment on that.
Yes.
So here I'll stand. As you know,
You can
I do.
introduce yourself.
We have these fabulous Jacob
whoa,
Dennis
whoa,
here.
whoa, whoa,
He's fabulous about to
Wait, I'm
speak.
just doing this
I'm
around.
definitely not fabulous. But as you know, I do trials,
I've heard that.
and I don't know how it works at work, but that right there, if the doctor relies on it, and Dr. Debbie Pershada probably knows this as well, if that is relied upon, that expert is struck.
Why?
Will not be allowed to testify. Dr. Seif got hit by
Boy, that was a long time ago.
Judge Kishner and others have been, because Nevada is a med-legal standard. It is not AMA. Now, AMA guides we have adopted for PPDs. That, if you write on that, you will never testify. I've actually struck, and I can say this, I've struck, but I use them. I've struck just about every neuro in Las Vegas from testifying before court for citing to that. Just so you know.
Tricky. Aren't you tricky?
That's why we call them breakfasts and learns.
That's it.
Yeah.
If you're interested in the orders, and why and everything.
No,
Seif is the biggest one, who I think is an excellent surgeon. Don't get me wrong.
Right.
I think the world of him. But he even challenged, he hired his own attorney and challenged she's kind of his judge, Kishner, on this. And now he's out.
He's like, no, we're not doing it.
Right, so when you do the AMA guides for causation, now, work council always has its little
Surely.
differences.
We're
I'm
surely.
just telling you. So, for example, Debbie Parshad did a expert report and said, hey, there's no way that this spine, I'm basing this off of AMA guides causation, and they cite to it. That is, I let it ride all the way to motions in limine, and then he will
Take
never
it out.
testify. And then that carries with him. Or I'll take his deposition and say, hey, you relied on this, boom, 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 done, you are out. So it's med legal standard in Nevada, which is more likely than not. And that is purely and solely for the medical doctor.
Okay, so what I'm gonna say to that is, thank you, you're so kind. So adjusters still need it, because adjusters need to understand the causation of it. I completely understand that when we get into court, and it's one of the reasons why we chose this set of people to talk about it, is because exactly what Jacob is saying. And that is, if the causation is real based on a medical, it still can't be used as what he's saying. It has to be based on possibility. That's the med legal point. But for adjusters, you still need to understand if it's even possible. And then once it's possible, then you can have that conversation with your attorney and with your doctor as to what is related on this particular claim.
I agree with that. I honestly have read this book. I think it's a good learning tool, but just remember
Yeah.
that it's the med legal standard in the state of Nevada. Other states, I believe California allows it. That's
You don't use that word.
Well, and we also are
They
going
also
to,
allow collateral sourcing, so screw them.
right, but we're also going to get into, because the doctors and by their presentations, what have you, of, I mean, you talk about that conversation, I would disagree that the insurance company is having a conversation about causation, or when you say, well, you picked up that phone to call the doctor to challenge them, can't wait to talk about that today.
Okay.
Yeah.
Did you pick that up right
Well,
out
I
of my
mean,
conversation? Yeah. No, absolutely. And like I said, it's gonna be a great conversation. So, let me talk about Mr. Kevin for a moment, because I do have a new bio for him.
Oh, yes, that's right.
I appreciate that too, Kevin, thank you. Kevin is a partner at Shook and Stone for workers' compensation. Kevin and his team have developed and grown the workers' compensation division to be one of the largest in the state of Nevada. Not only is Kevin an excellent attorney, Kevin also strives to give back to the community in several different ways. Kevin has been recognized by the Legal Aid of Southern Nevada multiple times for being at the top 50 club for pro bono hours. Appreciate that, Kevin, thank you. Kevin also volunteers his time through the inmate mediation program in federal court, acting as a mediator for inmate civil lawsuits, the Children's Attorney Project, this is so cool, representing foster children and representation of criminal defendants at various stages. Kevin is on the National Commission for the Anti-Defamation League, as well as the Regional Board for ADL here in Nevada. Memberships include the Nevada Justice Association, where he currently co-chairs the Diversity, Equity, and Inclusion Committee, and was recently awarded the 2023 Rising Star Award. Nevada Attorneys for Criminal Justice, Workers Injury Law and Advocacy Group, Nevada's Disability Prevention Coalition, that's us, and is a chair.
At the bottom of the list? Jeez, whatever.
Almost. And is also a chair at the LGBTQ section of the State Bar of Nevada. Kevin has been featured multiple times in the Nevada Law Magazine, as well as The Advocate. We appreciate you, Kevin, so very much. Yay! And beside him sits Mr. Dalton Hooks, who education with the University of Nevada, Las Vegas. He then went on to the William Boyd School of Law. Wow, back then, huh?
Not cool.
Today.
Not
I
cool.
just started.
You get off.
I
You need to get off the sauce.
I know, yeah.
Yeah. He has a minority law student, he is a member of Minority Law Student
Was.
Association.
Yeah.
Moot Court Honors Program. He's an adjunct professor at UNLV for both the William Lloyd School as well as the Department of Health and Education. He's a member of the Claims and Litigation Management Alliance, Nevada Bar Association, the MBI CLE faculty. I hope I'm not cussing. I don't know what that means. Sterling Education Services, CLE faculty, the William S. Boyd School of Law, Society of Advocates, that's really cool, Minority Law Student Association, and Environmental Law Society. Mr. Hooks is a founding partner of Hooks, Ming & Clements, represents clients in connection with employment-related disputes in the state and federal courts and before the administrative agencies. He also advises clients in various areas of employment law with an emphasis on workers' compensation and occupational safety and health. Mr. Hooks has been more than 30 years of experience in occupational safety and health and workers' compensation here in Nevada. He was formerly the Chief Administrative Officer of Nevada OSHA Consultation Section. Mr. Hooks is also licensed to practice before all state and federal courts in the state of Nevada and is a member of various local bar associations. He is an experienced trainer and educator. His unique background in training makes him an effective and knowledgeable advocate. As of January 2019, Mr. Hooks is proud to be recognized by the State Bar as one of the only of the handful of attorneys designated a workers' compensation law specialist. And I think you kind of set the bar on that because I'm starting to see more and more of that. They're trying to catch up. Just saying, they're trying to catch up.
We can try.
They can try. They can try. Oh, I can't do Kia. I gotta do Dr. D. Then we move on to Dr. D. So I'm gonna try that.
Dr. Debbie Pasha.
Dr. D is a renowned and highly respected orthopedic surgeon who has made remarkable contributions in the field of limb lengthening and spine surgery.
Yes, he does. He makes people taller.
Not just because you want to be though.
If you follow him on Instagram, you can watch his stuff. It's so cool. just so you know.
Yeet!
I know, it's cool. And he shows surgical stuff. Yeah.
No. With his extensive training and fellowship in these specialized areas, Dr. D has emerged as a leading expert in the treatment of complex limb and spinal disorders. Throughout his career, Dr. D has demonstrated exceptional surgical skills with unwavering commitment to patient care and a deep understanding of the physical and emotional impacts that you guys are using big words. Musculoskeletal conditions can have on individuals. He has successfully helped numerous patients regain mobility, alleviate pain, and enhance their overall quality of life through the expertise and the use of innovative surgical techniques and personalized treatment plans. Dr. D's passion for advocating the field of orthopedics is evident in his community outreach, his education, innovation. He actually participates in clinical studies and collaborates with fellow experts to explore groundbreaking approaches that can further enhance the patient's outcomes. His dedication to stay at the forefront of medical advancements allows him to offer the most effective and cutting-edge treatments. That's huge too. I really, especially with technology growing and growing and growing and growing, that's outstanding to not stay in the box. Beyond the surgical proficiency of Dr. D, he possesses exceptional interpersonal skills and a compassionate bedside manner. He takes the time to listen to his patients thoroughly, understands their concerns, and develops customized treatment plans that address their very unique needs. His warm and empathetic approach fosters the trusting doctor-patient relation, making patients feel more comfortable and confident in their journey. Dr. D's commitment to excellence has earned him the respect and the admiration of both his peers and patients. He is regarded as a thought leader and a key opinion leader in the field, frequently invited to speak at national and international conferences to share his expertise and insights. He contributes to medical literature and has been published in multiple journals. In addition to his clinical work, he's actively engaged in teaching and mentoring the next generation. Ooh, we so need that. He is involved in surgical training. Dr. D's skills, compassionate patient care, and commitment to advanced orthopedics has positioned him as a distinguished figure in the medical community. He contributes to the transformation of patients' lives, facing complex limb and spine deformities, instilling hope and enabling them to continue with the quality of care. That's awesome. Thank you very much. That's awesome.
I think
That's
it's just
awesome.
A well-qualified
And now-
panel.
And now,
No pressure.
such a
no.
care.
New kid on the block.
the new kid on the block. Do I get to add that on yours too? Because you are
Yeah,
very
sure, sure,
entertaining.
yeah, sure.
You're very
Keep it
entertaining.
PG.
See, Kevin
13.
gave me his own because he's tired of me living with him. So,
A
I'll go you
script,
first.
a script.
Dr. Kiak is a proud owner of Oasis Occupational Medicine in Las Vegas. And I gotta stop on the first sentence. He has his own med clinic. So if you're looking for an occupational rehab doctor who isn't associated with maybe like someone like Kid Center, you could absolutely, reach out because at this point in his life, he has not succumbed to them.
All right, that was awesome.
He was raised in Louisiana. He graduated magna cum laude at Tulane, and he had in chemistry in New Orleans. Ooh. And
Lot of
remained
chemistry
in
out
the
there.
city to earn his MD at Louisiana State University Health Science Center. He completed his occupational medicine residency training between the Mountain View Hospital in Las Vegas and the University of California in San Francisco, while simultaneously earning his Master's of Public Health at UC Berkeley before graduating in 2021. I bet you got some miles on that flying. Boy, bouncing 3 different U's.
Yeah.
That's awesome. Prior to his career in medicine, he performed extensive research in the basic sciences, which took him to the nanotech laboratories of Jülich, Germany, to the anesthesia department of Harvard University, and today he is one of less than 10 board-certified occupational medicine physicians practicing here in Southern Nevada, and he looks forward to sharing his perspectives and audience in the next few hours. And one of the greatest things I find about him, besides his abundance of injury without crack, is energy. It's amazing to me. I asked him what it was, because I need it, But I also like the fact that he constantly asks questions. When I've asked him and had conversations with him, and I said, well, that's not what happened. That's not what we do. That's not how it happens. He always asks why. And you can never take that. If someone is asking you why, take the time to explain it to them. And then, in addition to that, he then says what his opinion is. He doesn't just go, oh, okay, that's fine. Not okay. No. He will express himself, explain why, and why he does not appreciate it. And I really, truly enjoy the fact that he jumps in with full waders on, no matter who it is. I've had a couple of people come to me and go, well, he just goes too crazy with it. He doesn't. And I'm going to say this in your defense in the sense that one of the things I like about it is when I send an individual to you, you ask for way too much, and then you do it for a reason. And what I have struggled with in my career is administrators who go, no, you can't look at that. You have to look at this. This is the only thing we're looking at. Sometimes that's not the only problem, and you have to look at other problems to understand what your problem is. I just recently saw a claim where I had a total knee done on it, when in fact there was nothing wrong with the knee. It was a sciatica problem through the back. So if anybody had asked some questions in there, we wouldn't have got to a failed total knee because the knee wasn't bad. So always ask why. Why? And that's what I love about you.
It's quite a plug. Thank you.
Yeah, I really do. I appreciate it. Okay, and with that, let's start this maniac.
Right.
All right. Well,
Thank you for the introduction, Ann. Can everyone hear me okay? Is the mic on? Or am I loud enough? Yes, all right, great, perfect. So we've got a pretty contentious topic today, right? Causation and pre-existing injury. So let's just get right to it. What we're gonna do today, we already had our panelist introductions. We'll go a little bit into the definitions of causation to a layperson, medical professionals, and our legal team. And then I've got 3 juicy case studies straight out of my own clinic that we'll run through.
Yeah, see, that's fabulous.
Oh yeah, some of y'all might recognize some of these cases too.
Don't say it out
We're not gonna name names, right? But
Some
they're-
of them you won't want to identify yourself. Yeah,
these are juicy cases for a reason, okay? So,
yeah.
and then we'll do some closing thoughts, all right? So, these are, you've already heard about us. So, let's talk about what does causation mean, okay? This word carries a lot of weight, but what does it mean to an average person who isn't stuck in workers' comp, right? The way I like to look at it is something that brings about an effect or result, right? Cause and effect. Now, there's a lot of things that we now take for granted that weren't always, Yep. That weren't always so obvious, right? So if I drop a pen, what caused it to fall down, right? If you asked someone back in the 1500s, this answer might not have been obvious, right? I think most of us can agree now it's probably gravity, right? I know we have some, some contrarians always, but it's probably gravity, right? But there's a lot of things that right now we take for absolute truths that weren't always truth. They were even controversial or even taken to be the opposite, right? So anyone ever heard those commercials for asbestos, mesothelioma, right? So yeah, back in the day, when they were installing asbestos in every single thing, nobody knew that it caused mesothelioma. It took a lot of sick people, a lot of dead people, and a lot of litigation for us to establish this causal link. Smoking, lung cancer. Shamefully, I think docs back in the day may have even defended smoking. They said it used to be good for you, right? And now, after a lot of sick people, dead people, we now know that the opposite is true. Other examples of causation. So, people used to give mercury to cure syphilis. Does mercury cause syphilis to get better? No. The answer is no. But
It's
back
entertaining to watch.
in the day, they didn't know, right? What causes mental illness to get better? A lobotomy? I don't think so, right? Dietary. There we go. There's the contrarian. All right. We found him. Love it. The most recent topic, or one of the more germane ones now, is dietary fat. The fat that you eat in your diet, and heart disease. Right? So, does fat in your diet cause heart problems? It's kind of controversial now. It's not a slam dunk. Okay? Or most recently during the pandemic, what caused you to get COVID? Did you touch a nasty surface? Did someone breathe on you? Was it the vaccine? Okay, I've definitely heard that one a couple of times, right? So
No, it was worse. Duh.
oh yeah, it's always work, right? Wearing a mask, yes, I've heard it all, right? I think we've all heard it. Anything and everything caused COVID. So what's the point of this? The point is causation is not always a slam dunk. What we take as truths now depended on a lot of scientific research, and it came with a lot of controversy and uncertainty before we accepted it as truth. Okay? So let's get into how this applies to us in workers' comp. Yeah? Shall we? Oh, perfect. All right. So what is causation to a medical doctor? This gigantic wall of text, right? You don't have to memorize it, okay? I'm just putting it up here to show y'all what goes through the heads of scientists and physicians when they ask themselves what causes something in the medical context, right? In there is something called the Bradford Hill criteria. It lists a bunch of factors used to assess whether A causes B in medicine. Does antibiotic A cure disease B, right? And you evaluate all the stuff that I'm not gonna read. So let's simplify this a little bit, right? In the FDA, right, in order for a drug to get released, grossly simplified, they need to look at a lot of studies and be approximately 95% sure that there is a benefit from this drug, right? So why 95? What's so special about 95? Does anyone know why we picked 95?
Nothing's 100.
Yeah, okay, that's pretty good, yeah. It's arbitrary, that's the point, right? But it is a pretty high number, right? I think we'd agree 95% is a pretty high number. So why? Why do we need such a high standard, okay? If we're not 95% sure that this drug is gonna fix or do something good for disease B, we can cause a lot of harm to society by releasing something that we were only 50% sure about, right? There's some pretty crazy examples in our recent history, right? The one that comes to my mind is thalidomide, right? It was this medication given back in the day that caused a ton of birth defects, right?
Horrible one. That was for like headaches. Pregnant women with
Nausea.
headaches.
Yeah, so like nausea.
And nausea?
Yeah, and it calls fecomelia.
Yeah, it created flippers.
Created flippers.
The children all were born with flippers.
Yeah.
Yeah, see, that's how old I
Na-
am. I remember that.
Now they use for chemotherapy,
Nice.
for angiogenesis. So
That's amazing.
Scary, right? So when we're not super duper certain in medicine about a cause and effect relationship, a lot of things can go sideways. And so for a drug to be released and other similarly high stakes decisions, this is sort of the standard and the methodology we use to evaluate. However, that's not to say that this applies everywhere. We've already heard a couple hints about different standards, whether or not we're in the legal world or workers' comp, right? So let's hop into the legal side of things. I would,
Hop right over.
yeah, we've got lawyers here, don't we?
Yes, we do.
I'd like to invite our attorneys here to sort of define the three legal standards of evidence I have up here, and maybe comment a little bit about the numeric value that's supposed to come with it, and which one's applicable to workers' comp. May I have y'all step
Yeah,
in
we
here?
were just conferencing about how we want to start.
Yeah, I just,
Well,
hey,
we want to back up because
Oh,
the
of course.
first time causation actually comes into play in a workers' compensation claim is actually on the C4 because the doctor is asked about causation there. It is to a reasonable degree of medical probability, which again, we will probably get into throughout the discussion. I think it's important to note that that is great information from Jacob Levitt in regards to what happens if you were to litigate this. You get up to district court, they're like, what are you thinking? Okay. So I always just, I really am hesitant around some of the conversations, especially about causation, when it drifts outside of doctor-patient. Doctor connects it, doctor practices medicine, and that's their patient. It might be my client. It might be the employer's employee, who the employer is your client if you're the TPA or what have you. But that's about as far as those conversations should go. I mean, I don't pick up the phone and, doctor, what do you mean this is what your decision is? I don't do stuff like that. Now, that doesn't mean it doesn't go on or what have you, but I'm a lawyer, I'm not a doctor. I mean, my clients even come to me like, well, so what's going on next with the care? What kind of, what should they do about surgery and all those types of things? And my answer is always the same, that those are medical decisions. Okay, so I just say that because there is crossover here. This is why we did this event.
Yes.
But you're going to hear from the theme, especially from Dalton and I, that stay in your lane. Okay, this is not a discussion about the law, and we are not expecting the people in the audience, nor should you, to be going out and being like, okay, well, now I know. I'm going to go out and I'm going to start, doing the legal end of it. There's a claims end, there's a medical end, and there's a legal end, and everyone needs to stay in their own lane. I mean, including doctors. And so the causation that just right away on the C4, you're going to ask yes or no. Now, my view, Dalton can speak for himself, that is not conclusive, okay? If they check yes, that's not an automatic acceptance, okay? I've never, held that. Certainly it helps, okay, if we have to go into court. If they check no, it's not an automatic no, okay? But what I certainly have found is any time that the box is checked no, many of the claims are denied. I have argued recently that because that box was checked, even though that doctor wrote, I mean, you'll love this because it's contradictory, wrote no about causation, but it was doing his normal job, is what the doctor wrote. So of course I'm like, well, he just like qualified the response about causation, but the argument was from the defense was that, well, it was a claim denial. There's no medical opinion to a reasonable degree of medical probability because they checked that box no. And again, I mean, we're not going to get into about the arguments and what have you, but that's what I've seen. But causation starts right there. And it seems simplistic, and it is, but you can see, at least from my view, the fork in the road there that seems to happen. And so then, we decided we were going to talk about that first before we talk about other things about causation.
So, yeah, just dovetailing off of Kevin, I think that's right. You're going to hear a lot about causation. That's the discussion today. Causation, just breaking it down simply, is did X cause Y, right? is there a sufficient relationship between X happening and Y subsequently occurring, cause and effect. So, yeah, lawyers get really cranky, especially professors, about doctors dabbling in causation, because ultimately, when you look at the checkbox, what it asks is, doctor, based upon your review of the medical record and the claimant's description of injury, can you say that this injury is job incurred? Job incurred appears nowhere in the act. It is not defined anywhere, but it is ultimately the question that we're presenting to the court on a claim denial situation. So the trier of fact, which is the judge, whether that judge is a hearings officer or appeals officer or the Supreme Court panel, lawyers refer to the person who's going to make the decision as the trier of fact. The trier of fact makes that call. I don't make it as an advocate, and certainly the doctor doesn't make it by offering an opinion. And fundamentally, the C4 is flawed in the way that it asks the question, because it begs the doctor to become a lawyer and conclude the ultimate conclusion. What the C4 should say is, doctor, based upon your examination and the information that the history you've taken from the claimant, can you sufficiently link the injuries that you're seeing with the mechanism of injury? That's it. That's enough. That isn't what it does, so we have to deal with the world that we're in. But causation, as we go through the slides, whether you have causation is a question that ultimately is what the court is deciding. When we talk about the standards, and we're getting into that in just a moment here, but the standard of review is not the same as causation. Causation is an unknown quantity that we've talked about. It's somewhat nebulous, and it depends on what court you're in. If you're in district court, it's going to operate a little bit different than in workers' comp. But we have, specifically with regard to the issue of pre-existing condition, there's an important feature in that, and that the burden to make that case shifts from the claimant to the insurer, or TPA. It's one of the few places that it happens. I don't want to get ahead of where we are. But those are the main comments. And I agree with Kevin. What we don't want this to become a law lecture, because Jacob and Kevin and I have sat through many of those in law school. We've spent a lot of time pulling our hair out and fighting around the issue of what causation means as a legal construct, which is different from what it means for a doctor, right? It's a question of fact that's going to be determined by a bunch of factors. What does the doctor have to say about causation? What are the actual facts, right? So actual factual causation turns on what happened. These are the physical things that happened to this injured worker. At that time, was this person on or off the clock? At that time, was this person in or outside of the course and scope of their employment? Were they on public property? Was it somewhere in the back of the house? All of those factual considerations are extraneous to anything that the doctor might come up with in terms of mechanically, physiologically, this happened, and therefore this is the condition, and I believe that causation exists.
And I just a minute, and I'm going to respond to that, because Dalton and I are going to agree so much today. I like what you're going to
Shocking.
But, so, what he said is so key, because what you see, or what I see, is that trier of fact, the facts that have nothing to do with medicine, okay, are being funneled over to doctors. And again, it's not like they're writing, like the adjuster called and gave me all of this information. That's not ending up in the dictation, but we do find out about it. And so like again, what you are doing is you are funneling facts that are really meant for the judge about, well, here's the circumstances, well, you know, they said it's slippery, it really wasn't, or all these types of things. What does that have to do with the medical opinion? Certainly if the doctor finds out, oh, well, you had this alleged knee injury this week, and I found out you played basketball, and there's information like that. Well, that goes into, certainly different types of things that, okay, well, and if you can substantiate that, then that's information that's relevant for the doctor. But you chomping the bit to the doctor, even if the employer wants you to do it. Now, I think is unethical, okay? And I think that, again, like what was Dalton was saying, is that you're funneling facts into the doctor who you just need a medical opinion, and then it's up to the appeals officer or the hearing officer. They're the ones that get all the information, and that's Dalton's job then to come in and say, well, no, you have this medical opinion, but like he said, that's one part of it, because look at all this other stuff. And then it's the judge who makes the decision. And, you know, we think they're faking it is going to come up today. And this is going to be my stance too, is I'm like, so you're sitting at your desk or at your home or whatever, and even if the employer says, oh, I think they're faking it, and you're telling the doctor that, okay, go to your own personal doctor. I'm going to give him a call. I'll be like, she's full of shit. You'd be like, well, who would do that? I mean, so that's what I'm saying, is that just as I get really nervous that you're calling and things like that, because that is so inappropriate. And some of that, like what Jacob said, that can be stricken just because of the way that was obtained. But so it is so important what Dalton said about who is the trier of fact. Not us, not them, not you. It is the judge. They are the ones that get all the information in the event we have to litigate it.
Yeah.
So,
I promise you guys 30 days.
I have to leave, I apologize. I really
Do you
wish I could
really?
stay.
You.
Oh.
I kid you not, I would love to stay. Right?
I know. We do
I would
swear.
really love to stay, but Daddy's gotta go make some money. Literally. So on those lines, when you adjusters or claim or even attorneys call medical doctors, and Debbie Parshaw can do this because I did a depo on a doctor who will remain unnamed for this. They actually have to annotate that. It's in the 600s, NRS 600s. And if you get caught not doing that, it's a license, right?
Right,
So I took a doctor's license last summer,
right.
right? In a med mal. She can no longer practice in the state of Nevada, okay? But I was just currently suing Concentra, so it's exactly what Kevin's saying. When you call, when adjusters or attorneys, whoever calls, right, and communicate, say, hey, I don't believe them, whatever, it will come out. So I was deposing, it wasn't Fierro. She's the one that I think caused it, but, so, both NPs in deposition, I'll give it to you if you want to see it, right? I said, what do you do after you see the patient? Well, sometimes we call the risk manager, the employer, or the adjuster before we write out a C4.
Right.
Oh, believe me, I'm gonna have a field day, and I find people out, but I'm suing them for medical malpractice.
Right. Which that is. Yeah.
Believe me, the nurse practitioners have no clue that they just did something, I mean, they cracked gold.
Right.
You know what I mean? Hell, I'm gonna have a field day with that shit. But here's the thing, right? What Dalton and Kevin are saying is true, even in district court. So in district court, I don't make the decision on causation. I have two doctors that would, experts that would say, hey, no, I think it's this, I think it's this. The jury decides. Not me, not even the judge. Now, the judge is just a gatekeeper. Hey, did you violate certain rules to get to this opinion? That's one thing. But they're very right. And we don't, in my office, I have two of my people, Tanya and Emiliano here, we don't do that. We don't call, to me, that's between the medical provider and the client. Now, when it gets into litigation, if we're in the AO, whatever, we need to get more opinions, that's what should be done. But, it's just unfortunate that happens. But when it does happen, I will find it.
Right.
Especially if I'm suing for med mal, because she didn't know. And I got them on billing things too, which is really interesting. So I appreciate you guys. I'm Jacob.
And with that, he's gone.
So you're dropping all of these bombs and then
Right.
you're leaving.
Thanks, Jacob. Yeah.
Get out of here, Jacob. Get out of here.
Right.
Jacob left. But honestly, if you call and have a conversation, even though you're on the other side, right? As you can tell my person, I'm always happy to chat.
Thank you so much. Somebody lock the door when he leaves.
That's my parting gift.
Yes.
Thanks, Jacob.
Hey, Sue Harris got a question, then it's you, Cody.
I agree with Dalton that the C4 form is flawed, and I know
tried to modify the language, and, with the DIR, and it went nowhere. Because of the fact that the language is more of a legal, question to the doctor, and really is not conducive of a medical, question to the doctor. Now that there's new administrators over there at the DIR, do you think this is the time to try to, again, change the language in the C4 form?
Excellent question.
Yeah.
I just tried to do it about 6 months ago. And so Tori has been no more receptive to changing it, and I'm not really sure why. I don't think it's a philosophical thing. I think she doesn't want to change. She's got some new directives from the governor. They're supposed to get rid of some regulations. I can tell you that Chris Eccles, who is division counsel, did agree with me, and I thought we were actually going to get them to try to change it. I think they feel that they need a mandate from the legislature rather than to do it through just revising the form, which I don't think that's the case, but they've got to make a judgment based on more than what Dalton wants, unfortunately. So there's political considerations that they have to look at. As long as I'm doing this, I'm never going to stop trying to get that thing changed. So it is absolutely wrong.
And my opinion on that, Suhair, is that I believe that any change, I mean, there you go right there. They're telling them that we're not, an agency, okay, of the state is saying, well, we're not gonna change our form, okay, unless there's a legislative directive. So there's your benchmark, okay? So what my opinion is that nothing is going to change at DIR. Nothing until we go through the legislature and actually create new laws or modify existing laws to get them to do it. And that is an unfortunate spot that we are in. And it's those of you that were here or online, what have you, we had a breakfast and learn. They didn't show up even. Okay, so there just is no commitment. It really does need to work. You know, the machine has to work in all parts. Unfortunately, it is not. I mean, I just sent Mr. Eccles an email this morning saying 5 of my cases were held up this week because we're waiting on these D35s, okay? And one of them we've been waiting since March 28th. Now, I don't want, that's a huge thing, but I'm just, okay, so what are we doing here? And so it just is a problem. So it's unfortunately, I am not optimistic. I'm sorry, I'm optimistic once the next legislative session begins, which will be in 2 years, because that's going to way that we're going to make the necessary changes because they just will not do it without that, which I don't get at all.
But we'll teach them. Cody, question, answer, comment? Oh, wait, I'll do it. I can do it. Got out of the run.
Being relatively new to the Nevada statutes and all the things here, I mean, 2.5 years isn't that long. But what I've understood is that C-form, people want to make it hard and fast. What they listed is the only body part that's going to be listed. What the doctor put as a diagnosis is going to be the only diagnosis approved. But what I'm hearing is there's a whole lot of gray, and none of that really is just a starting point.
Yeah, it's a good question.
This is what they initially started with, just my back. But by the first 7 days, we're complaining of 3 other body parts. Eventually, you're going to have to address those. If the doctor only started with one diagnosis, but then they're reevaluated or they're evaluated by a different doctor and there are now 4 diagnoses, you have to deal with those. None of these are hard and fast rules on this C4. It's literally just a starting point. Am I seeing that from a legal and medical perspective the right way?
It's a good question. I want to answer it in 2 parts because first you prompted me something I wanted to say to Kevin that Kevin mentioned earlier. So he said that the C4 is not definitive. But if the yes box is checked, what did you say? It ain't bad to be in that position, right? And the reason that it isn't, again, the standard for causation to prove an injury by accident that's going to be compensable under the Act is a preponderance of the evidence. The claimant goes in with a yes on the checkbox, they have a preponderance of the evidence at that point. Right? So that's why it's a good place to be in. Now, I may be able through effort, maximum effort if necessary, to push things back in a different direction. Well, yes, the doctor checked the yes box, but if you look at the narrative, there are major issues. It doesn't look like that's connected.
Or if the doctor wasn't given the information.
If so, classic example of that, in my view, it is a deficit for any C4 that has a checkbox where the claimant has not given a description of injury. Because it asks you, based upon the description of injury above and your medical examination, can you link this as job incurred? That requires both things. So the doctor can't intuit the mechanism of injury and then say, post ipso facto, this is a compensable claim. That's one thing. But to the broader question, I don't want to say that it's just guidelines because it's meaningful, but there are ways that an injured employee who lists on the C4 that they hurt their elbow can have the claim expanded to include their knee because it's soft tissue. And you would do that under NRS 61C 160, which is subsequent injuries to the, or subsequent diagnoses or body parts to the extent that a doctor can link those to the initial injury occurrence can be added to the claim. But that isn't to say that the C4 that says only elbow when they meant elbow and knee isn't meaningful because it does something else. There's a concept of a statement by a party against their interest. And if I'm an injured worker, so when courts throughout the eons are trying to figure out credibility of witnesses and credibility of information, if I say something that is harmful to my case as a litigant, I probably said it because it's true. Otherwise, I wouldn't say things that are harmful to me. And so when somebody puts on a form that I only hurt this body part, it's going to be given an inordinate amount of weight against that happening unless you can explain it. And if you're explaining, at least for the meantime, you're losing. Now, you may be able to, no, Mr. Campshire will be in court and I'm going to say, well, Judge, I don't know, the claimant is now saying that their knee is hurting. What is the catchphrase? They're faking it. Mr. Campshire is going to say, this is preposterous. Judge, my client tumbled down a flight of stairs. So, yeah, the knee was the biggest problem. And then they started giving him treatment for the knee, which included drugs which masked the pain in the elbow, or vice versa, whichever way I said it at first. So, you can get past that. But C4 is meaningful. It's not just guidelines. Everyone should be, I'm sure that Kevin, to the extent that he addresses folks who happen to come in before they have an injury, that you have a relationship with, you want to be accurate in these forms. I'm stressing always to my clients, the employer and the insurer, these have to be accurate. Put down everything, because if you don't, yes, I'm absolutely going to call you out on that, and that's fair play. Why didn't you say it if it was heard at the time? You need to explain that.
I'm gonna actually have to back it up for a minute, because since you turned the chat team, my phone's blowing up. And I need to stop and go backwards to the administrators for a minute. Never, ever should you be calling a doctor. You just shouldn't. If you've got an opinion, if you want to say, hey, did you know that, okay, I've got a great one. I have an injured worker who has a hand injury. Come to find out that he is training for a fight with Merriweather in Dubois. I have all the YouTube, I have everything. I can't call the doctor and say, hey, have you seen the YouTube? That doesn't work. You have to put it in writing. Never should you be calling a physician. Sometimes physicians and attorneys don't like it when I find them in a bar or in a happy hour or in something because, I like to talk to them a little bit about something. But exactly what Jacob just said. As administrators, we have a lane. And it is not to medically manage that claim, to tell doctors what they're supposed to do and not supposed to do. It's not to tell the lawyer that this is what he's supposed to do. It is to deliver benefits, period. It's not personal. It's not your money. Deliver benefits, period. So when you're all freaked out because we're talking about, oh, we're taking this license and that license, yes, we can take your professional license for use going out of your lane and calling the doctor and saying, hey, Dr. D, did you know? Because here's the other thing. Do you want your mama calling your doctor? To say, oh, she's a crackhead. That's the reason she got a little doctor.
Right.
That's exactly
what if it's true?
It's for the doctor to figure out. And if my mama wants to tell my doctor I'm a crackhead, she can write him a letter. She can send him flowers with a note, my daughter's a crackhead. You know?
But what's interesting is they're going to address, like, this is gonna come up about when that, and I don't know how many do, but when that conversation is had, when the insurance is calling the doctor and saying this is all of this information, what she's telling you not to do, they're gonna get a response and what they're going to say, which I just think is key, because that's really what it's about.
What I want to say about this is this does not help. Don't do this for me. As Jacob said, it will come out.
It is
And-
ex parte communication.
Do you think
Well,
that's
no,
why
'cause it's not the court.
Concentra doesn't call us?
Yes, that's exactly why. Because he's hunting them. Yes, I mean,
But there's still a very, very popular physician who
Right.
does
right,
Yeah.
call us. I got the call yesterday.
right, right, because see, and that's a fine line that the doctors, and what's interesting about these two doctors is neither one of them ride that line, but that's a fine line, and the line is, okay, do I hang out with Kevin and his friends, or do I hang out with all the adjusters?
Yeah.
And how do I make everybody happy? Maybe,
It makes it very uncomfortable, because I've actually been put in that situation, and when we were fairly new, and it was like, Tree, what do? What do I do? And she's
Right.
like, nope, just stay in your lane.
Stay in your
Write
lane.
it all down. And I
But,
was like,
the doctor's calling Sandy because she's the employer.
Also inappropriate, yeah. But then that goes to doctors have like that, doctors have ethical,
Unless they're asking for.
I don't, yeah, I would say,
do
let's
you
not
have
make a
video?
blanket
Do you
rule,
have
yeah.
other
it's not a telephone call, that's a fax.
Right, but-
That's a fax, that's an email, that's something like that, but it's never a telephone call. If it's a telephone call, it's a lie, because it's hearsay and you cannot put the attorneys or the doctors in that position. Never call the doctors, never call their assistants, and don't call their pimps. Don't do any of it.
Whoa! Shots fired! Shots fired! Wow. You gonna take that?
It does. They call you and go, I want your doctor to say this. No, no. Let it be right. Let the doctor do his job, let the lawyers do their job, and you do your job.
And thank you for, yeah,
Yeah.
that was engaging, yeah.
Claim your power.
I heard the phrase, stay in your lane quite a few times just now, right? From the legal team, the claims team, right? I would like to, bring this back into where it comes up on the C4, right? Because I'm not here to convict the worker of their injury, right? There's uncertainty with every single C4, right? You have a video of the dude falling right on his right knee. Okay, that's pretty certain. And then you have hearsay, right? There's a percent to every amount of certainty, okay? And listen, these office visits are 20 minutes, okay? I'm not here to interrogate the guy about, well, when you fell, were you wearing blue or green pants? Like, come on, right? Like, this is very unhelpful medically and just in general, okay? Let's let me be a doctor and do doctor things, right? And not try to, convict the worker of, perjuring themselves or something, right? Dalton used the word preponderance of the evidence, which I have popped up all there on the slide. I want to make sure from our legal team that there's a percent, there's sort of a magic numeric percent tied to this. Would you care to comment real quick and then we'll move on to the next slide?
Yeah, that's one of my favorite rants, and it freaks me out when I encounter legal professionals who don't get this right. Preponderance means more than the other side. It is, so people will say it's 51%. No, it is not 51%. It is slightly more. So if you wanted to put that in a number, you couldn't because you need infinite decimal points, but it's 50.000 ad nauseum, one somewhere out in the very far infinity distance. It is, the Supreme Court of the US had a really flowery way of describing this. It's a scintilla of a wisp of a feather
Right.
Yeah,
on a
feather.
scale.
Yeah.
It's just more, slightly more, which is why I say, if the doctor checks the yes on the C4 box and that box is interpreted to mean the claim is compensable, that's more. If you're going into a hearing or an appeal and that's all you have on the defense side, you're losing because that's a preponderance of the evidence. And so even if the evidence is, so whether you have a preponderance, you get into, again, this is the trier of facts domain. If that's a jury, they are the triers of fact. If it's a judge, et cetera, as we discussed. So that party who's making the decision, the decider, as 41 Bush would call it, gets to decide what that means. And there are no bounds on how they interpret that evidence. And one other important feature is, in workers' comp, we have really one thing that you would consider a trial. That is the appeals office. The hearing before the hearings officer is important. It used to be more important when we had, seasoned professionals who, like Evelina Brown, no insult to the folks that are there now, but there was a time when the hearings served as to end litigation because you felt like you got a decision from somebody who really knew what was going on in workers' comp, and that would be the end of the discussion. There is a de novo review to the appeals office, but that is the only place where we have witnesses who are under oath, who are sworn in. To be clear, we've heard the word hearsay a couple of times. It's a term of art and it has a very specific meaning. Hearsay is any conversation that took place that was outside of a courtroom under oath being recorded. So videos are hearsay. Anything that didn't happen, if you're not in a court under oath, everything you said, everything that was recorded or documented is hearsay. So hearsay is routinely, to be also clear, in our world, in workers' comp, the rules of evidence are relaxed. It's not defined. But hearsay is routinely entered because the idea is we're trying to get to without a whole bunch of hubbub, Jacob deposing all the doctors in town and yanking licenses left and right. Yes, he was. Yanking licenses left and right and all the stuff that he's doing. If we had that happening in the workers' comp system, we would never get a simple claim dispatched with. So the rules of evidence are relaxed. The speed of the trials is truncated. We have limited tools that we can use. That trade-off is for speed, to get these things through the system. So I hope that answered the question.
And then just also in regards to, we have an agreement about preponderance of the evidence, okay? But then the reality is that and this is just, again, sharing from how I communicate with people because of the clients I represent, you can't just be like, well, it's our burden. It's our legal burden. They don't know what that is. And then, well, it's preponderance of the evidence. They don't know what that is. So I use a visual of a teeter-totter. That's it. So and it just is weight, and where is the teeter-totter, okay? What if the teeter-totter is equal? We have Nevada case law saying what the end result is there. If the appeals officer finds that the evidence is identical and it's 50-50, we lose, okay? So, but I use the teeter-totter. Just to piggyback off of that is that Dalton expressed concerns about the actual adjudicators and what have you, and certainly I would be remiss if I did not always address my concern with the court system as a whole. The broken system was exposed, unfortunately. A complete revamp of administration. The director's no longer there. The senior appeals officer, who was the big problem because she did nothing from 2018. When the cases started to soar in 2018, and they were coming where the appeals officers had like 400 to 500 cases. Now they have 1,800 to 2,000, okay? The senior appeals officer's main job was to do reporting where, if you're the boss, you'd catch all of that, and then you go and then adjust quarterly. She did nothing. She hadn't even run any of them, okay, for like 5 consecutive years. So the court system has literally let all of us down, okay? It's not just me. It's not just you. It's all. No one wins when the court system has a 14,000 case backlog, okay, and the senior appeals officer was there 35% of the time, but she's working from home. No plan to clear out those 14,000 cases, okay? So now, people are gone, what have you, but there's some changes, and so that is a big part of it. If we had a court system that was operating like a court and that there was access to justice, that would also be an enormous help, and I believe that is coming. Again, new administration, new governor, new everything, and Governor Lombardo was a police officer. And so it is exciting that there's going to be changes. which again is going to be beneficial to everyone. But so anytime we bring up anything about the hearings division over there, it is important for everyone to know the facts of what was out there and the changes that needed to happen and did happen. Because if you were a CEO leading that company, you would have been gone. And so would your cronies. So, I mean, but I just always have to, you can see I'm passionate about that topic, but it really impacts all of us. And then, and then the doctors can, what does it do to the care of the patient?
Yes. Thank you for saying that.
Because that takes you right into the next.
Right, so look, right, the whole time everyone's arguing about whether they're wearing blue or green pants or whatever facts you want to argue about, right? There's an injured patient, right, in my office, in Dr. Debbie Porchard's office, who's not getting care because of a checkbox or they didn't remember some trivial detail that they didn't know was going to be important, right? So do us all a favor, right? This is creating a lot of friction, clogging up the courts, and ruining people's lives, right? These patients, most of them want to go back to work, okay? Let's help us help them get back to work, okay? Oh, yeah, thank you. Appreciate that. All right, do we need to go into this wall? Do we need to go more into the way the law is written? What do y'all say?
No, you know what, but I'll just make one comment on the previous slide, how they had beyond a reasonable doubt, clear and convincing evidence, and then preponderance of the evidence. So we address preponderance of the evidence of workers' compensation. There is clear and convincing. We don't use that. We're not going to go dive into that, but I'm sure everyone has heard beyond a reasonable doubt. That's criminal law only, okay? That's all or nothing. That is a jury, Sixth Amendment rights. I mean, there's all kinds of things. I do see, people trying to be like, well, you've been in jail or something. You need to tell us what this is. No, we don't. But anyway, the legal burden, again, imagine teeter-totter versus beyond a reasonable doubt, all or nothing. Sometimes I think that we would run into, I'm like, well, it's not insurmountable, this teeter-totter, or like more than none, or what have you. You can see the big difference, okay? Why? Obviously, the stakes are much higher if you're going to be going to prison versus, an injury that hopefully is not going to completely incapacitate you or remove you from the workforce. So.
Only thing I would add to that briefly is their clear and convincing standard does raise its ugly head a couple of times in the statute. One of them is under NRS 616C180, which is for site claims. You have to have clear and convincing evidence also with regard to reopening. If you're trying to reopen a claim within 1 year of it closing, it's another place where there's a clear and convincing evidence needed. So there's a couple of places. It is it's limited to, but it is more than a preponderance and less than beyond reasonable doubt. Not very well defined. The one way to look at it is that judges and triers of fact know what when they see it. And that's what we're trying to convince. That's a lot of it.
So let's go on to aggravated, precipitate, and accelerate.
Right.
Yeah, thanks. So I just slapped pieces of the law up there. Invite the lawyers to comment on the pertinent parts for our discussion. And I want to make sure we leave time for some of the cases too, because they're juicy, okay?
Yeah.
Go ahead.
Yeah, I don't have any comments. No.
All right, great, perfect.
So I guess, let me just hit this quickly. So 175, the key features of 175, I mentioned one earlier, the last paragraph. The burden switches to the insurer. If the claimant can show that even though they had a pre-existing condition, it was aggravated, precipitated, or accelerated by the injury that subsequently happened, that claim is going to be compensable unless the insurer can prove by a preponderance. So it's the same for us. It's not, we got to have a whole bunch of evidence, just enough to demonstrate that it's more than what the claimant brought to bear. Normally, that burden rests with the claimant. It switches in this case, and it makes sense. We're switching the burden because you're now saying to the claimant, no, you can't have this claim because you got this pre-existing thing, and that's really what's going on here. Well, show me, says the trier of fact. Prove it. It's your burden. Okay? So, as far as aggravates, precipitates, and accelerates, what I will say about these is, lawyers, we like definitions, and we like those definitions to be in the place that they belong, which is in the enabling act. Aggravate, precipitate, accelerate are not defined in the Nevada Industrial Insurance Act. And So what it comes down to,
We just made that up.
Right.
well, there are words that exist, so what we as lawyers have to do in the case where there isn't a definition in the Enabling Act is we turn to, is there other controlling case law where this was defined in the jurisdiction that you're in? What does Mr. Webster have to say, right? So we go to the regular dictionary.
I like better.
We can't use WikiLeaks. And ultimately, but there is, some evidence. So whether something is aggravated, it's, the textbook definition is it made it worse. Like, you're in a bad mood and your kid is aggravating you, right? You understand that. Made you worse, right? So precipitates is set the stage for something to get worse, or accelerates. It was already something that was, sure, I had some arthritis that was eventually going to be a problem. It was slowly getting worse over time. By the time I was 70, maybe I wouldn't be able to walk very well. Well, this incident accelerated that deterioration, and therefore, because there is cause, right, back to this causation concept, you caused it to get worse. And that's really what all of these are about. Aggravates, precipitates, accelerates. The injury that happened in the course and scope of employment allegedly caused that pre-existing condition to get worse. And if that's the case, causation lies with the job, and therefore it should be a workplace injury. And where we're going to get whether it aggravated, precipitated, or accelerated is from our doctors.
Thank you. Wonderful. So I'm new to the game, okay? This is the thought process that I use whenever I see a worker come in, right? I'm a doctor, I'm a work comp doc, so I try to throw everyone a bone here, make a useful causation opinion. So in my mind, I ask myself first, what is the diagnosis, okay? This is not always obvious. It's not always a sprain. It's sometimes a tear. It's the back. It's not the right, like, we're not 100% sure, okay? I'm wrong more often than I care to admit. Hopefully Dr. Tevye Prashad's wrong less, but doctors are wrong, okay? We're wrong sometimes, right? So we need to know what the diagnosis is, and then I ask myself, is there a reasonable medical probability, greater than 50% chance, that this work, maybe I should have put event, right? Work injury, aggravated, accelerated, precipitated it, whatever that means, right? Ask Webster, ask WikiLeaks, whatever, right? Here's the point, okay? If we don't have a diagnosis, we cannot give a useful causation opinion, okay? So a lot of diagnoses, right, can be made by history and physical. Not every diagnosis can be made that way. Some need imaging, right? So denying the MRI doesn't help anybody, right? Seriously, right? You're waiting for whatever's in the shoulder to get worse. Like, I don't know, what are you doing, right? Like, stay in your lane, please. Right?
Okay, and I'm gonna add one thing to that too, and I agree, and I love your enthusiasm, but if you deny that MRI, what are you doing, what are you doing, what are you doing? Because you go to court, there's not a court in America that's gonna support you for denying it. They're gonna say medical question, make it work. Doctor?
So my question, so a lot of times when I see those denials at the ACOM, whatever the occupational medicine guidelines are being quoted, they're not always being quoted by medical professionals. Now then, my question is, can an adjuster rely on those guidelines? My opinion is no, but.
Only if they have an MD after their name.
Well, but hang on a second.
But I see
LPN,
that
RN.
quoted as a reason for denial that.
Right, there's some nuance here. There's some nuance here. So first of all, yes, with regard to denying an MRI, but it's not as simple as you denied the MRI. If, again, you have to consider the totality of the circumstances. So in a factual case where a claimant, let's say, you mentioned earlier there's a video. Claimant says that they injured their head because they smacked their head on the concrete after they fell and hit their knee. C4 says only knee. We got video. Claimant never hit their head on anything. In fact, what the claimant did was laid down on the floor and then started rolling around. And I've had that video, okay? So you're gonna deny the MRI. Even if it's not that egregious, if it's a completely different body part that has any business being inside of the claim, you're gonna deny the MRI. And if somebody gives you grief about it, you're gonna say, Dalton told me to. And that's why we're going to do it. So all cases are not created equally, number one. Number two, Doc, with respect to what you're seeing in terms of somebody whipping out the ACOM guidelines and saying, no, I'm not going to give you this diagnostic that you want. The ACOM guidelines are incorporated into the Nevada Industrial Insurance Act by reference. They are the law. So if you've got learning, if you've got eyes and ears and reasonable brain, you can interpret the guidelines as a basis for denying treatment. But that's not going to happen in the context of at the beginning of the claim where we're talking about. It's going to happen in the context of ACOM guideline says that this should be done treating. We know they're guidelines. It's not the law, but they are guidelines and they are incorporated into the law. 6 months PT, this person ought to be back to work in a normal case. We're now a year, 2 years out, and we're still asking for PT, and you want to MRI it, we're going to say no. And we'll let the court sort that out, and that's what the court is for.
So,
But a lot of times they get denied at the beginning, so then they're delayed treatment, so by the time the doctor actually does see the patient, it's a year and a half
It can be,
after.
all I'm saying is they're not all created equal, and there's going to be cases where it is the exact right decision for the adjuster, whose job is to adjust the claim in accordance with Nevada law.
So-
It's the law is, the act is not a panacea. There may be things that a patient, an injured worker needs that just aren't available to them under the act, because the act isn't supposed to be, it's not general insurance. And it's not, as our Supreme Court put it, it is not a panacea to cure all the ills in the world. It is a very specific insurance for a very specific type of injury occurrence.
Okay, good.
Okay,
Comment?
so, yes, okay, so I work for Las Vegas Neurosurgery, so I work for a neurosurgeon. We get a transfer of care for a patient, say cervical. On the C4, it says cervical strain / sprain. So when we get them, no MRI, maybe an X-ray. So then we put in for off to get an MRI. Probably gets denied the first time, then when we get it again, and it gets an MRI and we find out it's cervical radiculopathy, then I put in for pain management. So when I put in for the referral to get pain management, it gets denied. Well, this is not cervical radiculopathy, this claim was for a cervical strain.
yeah, oh, thank God for bringing that up.
And I have a patient. Hold on.
This happens to you too, right?
Oh, yeah, no.
Literally, we waited 2 years to get authorization for pain management.
Because
Oh,
they
yeah.
have to
That
go
happens all
back
the
and
time.
expand the scope of the claim, which I do understand to a certain degree. I understand that obviously it's not a sprain strain, but when you send to a specialist and that specialist has an MRI and they're trying to give you a proper diagnosis and they do, then they get denied, right? So it's not radiculopathy, it's still a sprain strain. So now you guys have to go and litigate, which draws it out even further.
And regretfully, I think there's people, right, and regretfully, I think that that's a reflection of the youth in, excuse me, hello.
One at a time.
We understand the bitch, we understand. I want, that's as a result of our young children administering plans. And I hope that the 110 that are listening understand what you guys are saying. And that is, use your power for good.
Well, can you
So
look
look
at
at
it on
that.
a rule-out basis and everybody's
Right.
okay with that?
Right, right, so that's exactly right. If you have a strain and you sent it to a specialist and they're asking for additional diagnostic, don't be ridiculous and deny it.
But at this point, they're asking for injections, right?
After we
Because
find out.
they have an MRI, they can tell you that this is not a sprain strain, I'm looking at it and it's whatever. And so when they try to go and say, I need an injection for this diagnosis, well, that diagnosis isn't part of our claim.
Or even more so, they send that injection recommendation from Dr. Flangus, whatever, to the UR.
To the gynecologist.
Who is almost an automatic denial. Now again, just it's written into the law, so there's nothing illegal,
Okay, wait,
but, oh yeah.
UR
yeah.
isn't accepted. I mean, we can't stand on UR right now in Nevada.
They all do.
That's what happens.
Yeah.
You
Yeah.
can?
Yeah.
Deny things, yeah.
Oh, yeah.
We don't use it in Nevada, but certain companies who are nationwide.
Well, no, we do use UR in Nevada.
Which screws everything up.
So if you have an
Yeah.
MCO, the law is very clear. If you have an MCO,
Who has an MCO before,
there are a
besides
few,
Corvallis?
there are a few
Well,
out
the
there.
catch is they claim they
Corvallis
are
here.
sometimes, even though they're not, but yeah.
Corvallis Sierra.
Metro has special.
Some doctor sitting in another state is reviewing it on paper, that's what it is, like, whatever you're gonna call it, but yeah.
Let me defend the MCO process just real quickly, because I gotta, he finally found something we can disagree on. We knew this was coming. Look, the MCO, the UR review process requires, and every report will have, I attempted to call the doctor. In many cases, they will speak with the doctor. And I don't think that it's always a guarantee that it's going to be denied. In fact, I think that the doctors who do it do make an effort to reach out and find out, okay, please explain, I'm not clear why you're doing this. Those, in my experience, and Kevin's might be different, the MCO UR review cases actually move pretty quickly through the process. In my experience, they do, in terms of litigation. And so I can speak from my own experience, and I know what it is. They move pretty quickly because they skip the hearings office because it's a two-step within the UR review in the MCO, and then you go straight to the appeals officer, and you're there litigating that issue. If the appeals officer finds a medical question, because there's not going to be a whole bunch of other witnesses, we need to continue things. They go on the stack, we can move them along pretty quickly. You get the medical question, and you get an answer, and the judge is able to make a decision. So relatively speaking, those cases move faster than most.
We do have some online. Corey Chappell, I'm going to open your mic up if you want to ask your question.
Kindly.
Kindly.
Can't hear.
I don't think Corey has
Can you
my
hear me?
Yep, we
Oh.
can now.
Okay, so I just sent a text to Christy and Trish, and I always suggest whenever a doctor is making mention of a body part that we don't accept or we've approved imaging on a rule-out basis, just send a letter to the doctor that's not leading immediately versus waiting for an interim order or an IME to be ordered, asking the doctor, can they correlate it by 51% or more? Are the contributing factors that are impacting it? But that letter,
It's not
if
51.
the doctor responds that they can correlate it, approve the care, expand the scope, and keep it moving. I mean, don't wait for an interim order to ask you to question the doctor when we can do that early on.
I agree.
Cool, yeah,
That's all I have.
I agree.
thanks, Corey.
All right, wait, we got one more. Ashley Isbell. I'm going to turn on your mic.
Hi, Ashley, what a pleasure.
All right, unmute yourself, Ashley, and go ahead.
Hi everyone. So building on this, and I know it's a topic and a pain point for everyone, and I think, speaking to the youth and the new claims people that are coming into this industry, one of the things that's important is to, avoid the litigation, give the person the care, pay the benefits of nothing more, nothing less. But a lot of it comes from unclear medical reporting. So if a doctor wants me to expand my scope to include a radicular diagnosis, put it in the report. 9 times out of 10, I've got to bump my reserves up, and I need to explain to my customer why I'm doing that. So if I have a doctor explaining to me, hey Ashley, we need to increase the scope of the claim because of X, Y, and Z, that's going to cut out so much. It's going to cut out that 2 years. It's going to cut out the legal process. And then if we have a medical question, we can't schedule an IME without going to the court. So it really needs to be a partnership from all involved in this work comp process.
I love that, that's exactly right.
Sure, totally,
And with that upbeat, let's take a break.
We are going to take a break, and then we'll be back in 10 minutes, 10:46.
Thanks, I didn't even give you a chance to speak.
Oh no worries. I'm just taking it out. There's not much to say, but it's interesting. I'm just letting people kind of do their little thing. And,
No, I forgot how vigorous the discussions are.
We
I'm
wanted
very,
to focus more on the medical. It's gotten really too.
Well, it's all right, the medical stuff's coming up, right, so.
what the case is and that kind of stuff. And I'm also very like neutral based. So.
Take your mic, I'm
Are
just
these
going
not
to
working?
turn them off.
If you can make the phone call, but you have to dial.
I remember now. Yes, you came to my open house. I have not reciprocated.
No, don't worry. Just let me know what works best for
Yeah,
you,
sure.
and then we'll set something. We can even do lunch between the two of you, and then so then
Yeah,
see how we can
would
help
love
each
to.
other out.
Yeah, because look, I mean, I don't do injections, right? I need to refer. I need cavalry, right? I need to know all the guys who clean up my messes.
So yeah, just let me know what works best
Sure.
for you. Okay.
I'll definitely follow up.
All right. Thank you.
Of course.
Okay, let's wrap 'em. Let's get it together.
Give you some chance to comment
We're
on the
heading
medical
towards
risk
town.
factors for RC tears. This will come up a billion times.
You're gonna jump right to the case study?
Yeah, we should. Yeah.
Very passionate, so
No, because especially when we get to
it's very helpful. I mean, I think it still helps to like put
They are, but
all
you-
the same people, like all the people
there
who are
is-
supposedly on the other sides of the teams in the
thing is,
same.
I probably should have opened this one. This one was a really hairy case. So,
Yeah, no, I looked at it.
Where like I had to go argue with a bunch of assholes to get this thing moved, and it did move. And they're still arguing with me. It's in court right now.
Yeah, and
Unreal, dude.
and that's dangerous too. 'Cause,
Unreal.
no, I mean,
Just shame. If they're in the audience, shame, dude.
All right, let's sit down, let's get it going. Let's get it going. Come on down. You're the next contestant.
All right.
The prize is right.
The prize are 3 juicy case studies.
That's right.
All right. We ready to get started? All right. So, straight out of Oasis Occupational Medicine, courtesy of one of y'all's referral. So, let y'all, you could read the wall of text, right? But here's a custodian, 61-year-old lady, got a lot of diabetes, smoker, and she came to my clinic as a transfer care, some right shoulder pain and weakness a couple hours after her shift. She said she was pulling the trash out of some cart, doing it kind of like this, yeah, show and tell, like this, okay? And apparently the lip of the cart was pretty high, so she had to get her arms way up there. And she was saying somewhere in the process of getting her arms up there, she developed some right-sided shoulder pain and weakness. And yes, there was security footage. It was shown to me very eagerly. Okay, so let's start with causation medically, okay, as the story is described. Do I, Dr. Keok, think there's a reasonable medical probability that the events that she described led to the diagnosis, which, by the way, was a rotator cuff tear? My answer is yes. Dr. Devi Parshad, what would you say if this case showed up to you?
I mean, I'd probably agree. I mean, she does have some risk factors. So we're talking a little bit about pre-existing conditions and that sort of thing. So you want to consider some of those pre-existing components. I mean, the patient's age, she's 61. So, rotator cuffs can be difficult, right? I mean, they're very common in asymptomatic patients. If you look at some of our literature, in the JBJS is an article that looked at rotator cuffs in asymptomatic patients. I think it was about 50%. They correlated age with the percentage of rotator cuff showing up on imaging. Meaning if you're 60, there's a 60% chance. If you're 80, there's an 80% chance. So there is some, risk of having this diagnosis, pre-existing and present in patients, especially patients of older age. In addition, the patient has a history of diabetes, history of smoking, all additional risk factors for this type of event. However, you have to look at all, you have to be a detective, look at all the circumstances. Has this patient had any other complaints before? Have they ever seen anyone for a rotator cuff problem or shoulder problem? Were they scheduled on like Dr. Ong's list for Friday for a rotator cuff repair? Right? You know what I mean? And then they had this event. So you have to look at, it's not just the mechanism is biologically plausible, right? The way he described it, the way he demonstrated it, I was like, okay, yeah, that makes a lot of sense of why this could occur. Maybe there were some small risk factors, but it certainly, accelerated, it certainly aggravated, it certainly precipitated the event, maybe completed the tear. Another reason why you want to get imaging even right away, right? If this patient comes in, you want to be able to, get this patient to see a medical provider because they're going to be able to give you more information. Am I going to look at this patient and am I going to see, tons of atrophy or like a sunken sign on their scapula or a sunken sign in the infraspinatus and think, wow, this has got to be old because that atrophy wouldn't have happened in 3 days, you know what I mean, if they have no muscle there, which is why, an MRI would be helpful to look at this pathology because then I'd be able to comment on it more, right? I'd be able to give you the information. Surgeons are busy enough, and I think providers in general in Nevada and here are busy enough. I don't want to treat things that I can't help, right? So the faster I get it going, the easier it gets everyone off. We're all on the same team. And everyone's arguing, but like we're all on the same team, like the attorneys, both the defense plaintiff, like the adjusters, the patient, and all of us are really on the same team. We just want to push this thing to see if I need to do something. If I don't need to do something, does this need to be closed, or what is the answer and how we can kind of. And I think 90% of the time we can just do that really efficiently. But then if you start like denying things, start doing this and then this, then you like put up walls, right? like the providers who like tell me that like trauma guys would say, oh, I hate doing workers' comp because the fractures are healing before they approve me fixing them. And I'm thinking, what? That's crazy. And so you start putting up walls, and then even to the patient. I mean, maybe this patient was fine, but then they started hearing, oh, my adjuster's not calling me back, or like they denied this, they denied this. They keep hearing these things, then it starts putting up in their mind this like resistance also, right? Where like no one is trying to help them, so they start advocating for themselves. So maybe this thing would have been a 6-week ordeal, but now it's become like a 1-year ordeal. Because you put all these things there because we're not on the same team, when we're actually all on the same team. So anyways, back to the MRI. So if we did get the MRI, we could look at certain factors, right? Like, are there bone contusions? Where's the level of the rotator cuff tear? Did it avulse off the bone? Are there bone contusions to go with that? Is there hemorrhagic changes? Are there fluid signal changes that would then make you guys say, hey, look, 100% this was acute. 100% it was acute. You know what I mean? Because I'm seeing an effusion, I'm seeing all the things that are very, in keeping with an acute event, so you can sleep easy at night. You know what I mean? Like knowing that this is definitely acute. So, or maybe I'll see other things. Maybe I'll see marbling of the muscle. Maybe I'll see fatty atrophy. Maybe I'll see all these changes that I'm like, you know what? It actually does look a lot more chronic. These changes wouldn't have happened in 4 days or 5 days or 6 days or 7 days. You know what I mean? Or then maybe it's somewhere in between. Maybe there are some acute findings and some chronic, and maybe it's somewhere in the middle. Maybe there was some pre-existing pathology and then this occurred. So, but that's where we are involved in that sort of process. But, we need help to get to that process, to give you that honest opinion of what we think. So.
And what we would ask for as administrators is, as you're doing your brain work and doing that you are transparent with what's going on. When you see that MRI, you can say to us exactly what you just said, because obviously that's not our lane. But if we could get an explanation, okay, I looked at this MRI, this is this, this is this, that would help us. Instead of, a lot of times I don't see a report from the physician commenting on the MRI. I only have the MRI report.
That's unfortunate.
Yeah.
Let me, I love what the doctor said. And if I
love
saw
what the doctor
more reports from doctors in these cases that said, here are my acute findings that make me believe that this isn't a recent occurrence, it would be wonderful. I just want to say on behalf of the claims adjusters that we have to understand, there's a lot of pushback on denying things. The Act requires administrators to look at these cases. If you let it go, you can't get it back. So there is a reason that they are denying treatment that is questionable, whereas a doctor will look at something that is questionable and be able to, as one guy, work through that, do another test, do a range of motion and figure out in real time whether that doubt is legitimate or not. The adjuster only has one tool, and that is to say, I'm sorry, I have to deny this at this time. That should not be given some sort of malfeasance or idea that there's something bad about that. The system is unfortunately then going to have to do what it does with a doctor opining, et cetera. The fact that those things take more time, we understand that practically this means that a patient's treatment may be delayed, and that's unfortunate. But the whole point of this system requires the adjuster to look at that and say, I can't say yes to this.
Right.
That's why we have advocates on the other side who will say, I'm sorry, I get that Ms. Jones denied this case based on what she saw here. However, my guy needs treatment immediately, and if that's the case, a doctor can say, I'm sorry, this person needed surgery immediately, and that's going to be something that is built into the Act, and you can go ahead and do that. And we can pick up the pieces later in terms of who's paying for it.
We've got a case with that emergency surgery coming up.
And just for the doctors to know, we cannot go back. Once we accept something, it's done.
It's done.
So even if you
Unless
come.
new evidence is found
No.
which you can justify.
No.
No, you cannot. It's no.
No, and let's go
done.
back to
I've
that.
seen it done.
They were wrong.
I
And
have
they,
some
I know, but they're
denied
wrong.
stuff that has been approved.
Okay, but I'm telling you that legally, we can't do it. We can't do it.
Yes, it has been done many times.
Yeah,
But I just want to slightly comment. I respect what you're saying from a legal standpoint, that the adjuster, their only tool is if they're not sure to deny and then get some other opinion, be it IME, be it whatever. The issue that we as doctors have with that is, on top of all of the workman's comp laws and everything, we have a duty to treat, which is actually overarching duty that we have that outweighs anything in workman's comp. We have to provide the best thing for the patient.
Understood.
Delay of care is a real thing and will worsen the outcomes.
I fully understand that.
But a lot of adjusters do not understand that it is
Yes.
not that we can freeze the patient in time, put them in a freezer, then once we figure out all the legal stuff, get them back out and restart the treatment.
Hey, Doc, I was.
3 months delay
Absolutely.
will worsen the overall outcome and disability
Yeah.
and his ability or her ability to earn money at the end.
Okay,
There's a
we get it.
No, fully understand,
we
Doc.
fully
I was
understand.
pre-med until I did sociology of medicine, where we learned about malpractice and these types of things. I was like, that's not the life that I want. Thank you. So I get it, fully.
So you can
However,
approve under medical investigation.
Absolutely.
That's what you're hearing.
medical investigation is a tool that can be used in those cases.
Right, but that's not, I'm gonna pay for this and then go, oh, guess what, I changed my mind.
Each
Well,
case
let's
is
use my
unique.
total, let's use my total knee.
It has been done.
Let's use my total knee. I got a total knee that isn't mine. It's not mine. But it was already accepted. So now, because we have a fabulous thing called errors and omissions, the client said, hey, that shouldn't have been accepted. So me as a personal TPA now has to pay for that because I cannot, in the court systems, go back and go, guess what I figured out? I figured out it wasn't a part of mine, so I'm just gonna let that total knee go.
I had an entire claim denied 1 month after lumbar fusion, so no post-op care was done.
Right.
Different state, but
Right.
same workman's
Right.
comp is not that different.
But it's not the same, sir.
It's very different.
It's not the same. In Nevada, if you accept, you cannot go back and deny. I can deny all day long. I can walk around and deny all day long and then come back and accept it. But
If you
I
pay
accept
for it,
something-
you can't, you own it too.
Right,
It's not just accepting,
Right.
paying.
right, right.
Right.
You don't,
So no,
you don't review your bills and realize that you just paid for something. You
Right.
bought it.
Right, so it's one of the reasons, that's one of the lanes for the adjusters, is to make sure, because one of the things you said, Doc, which was absolutely true, was as physicians, you're obligated by your oath to take care of a patient to the best of that patient and to do whatever that oath says. But, and that's fine, and we, gosh,
It's
I
not just
respect
oath,
it.
it's actually a legal requirement. We'll lose our license.
Right, exactly.
Even if we don't.
Yeah, that dude's gonna come for us if we don't.
That's, yeah.
Jacob's gonna.
Yeah, he's chomping at the bit.
Jacob's coming, but I just wanted to make sure that the rest of me understand. Keep going, sorry.
Cool. So look, one factor that came up in this case, right, was the security footage, right? So, no one shows up with security footage to my office out of the goodness of their heart. I would love to believe y'all care so much about the patient. You want to make sure they got the best possible care, right? But, you know, you know what? Some people do, some people don't, okay? Because this footage came up because, like, well, that trash bag is only 5 pounds, 6 pounds. Okay. Can you weigh a trash bag in a footage? No, right? Is there scientifically a weight that is impossible to tear a rotator cuff? No, okay? So don't be a scientist, you're not, right? Don't be a doctor, you're not, right? There's a trash bag that's being pulled up this way. Medically, plausible enough for me, right? You might find a doctor disagrees. That's fine. Get another medical opinion, right? But please, please, please don't introduce a ton of friction into this process and just start denying everything because you don't like the way it played out or the employer's, getting mad at you, okay? You're gonna lose probably in court. Now this person who had a 6-week-long injury, right?
Depends on who your lawyer is.
If you have Kevin,
Thank you, that's what I was getting at.
Kevin
I'll
representing
win.
you,
Yeah.
you gonna lose.
Thank you. Didn't build that practice in my bio from losing, I'll tell you that right now. Didn't get the Rising Star Award because I lose, let me tell you. Yeah.
Interesting. Somehow I didn't either.
All right. Oh, well, let me stay in my lane. I shouldn't comment on court, but
Look, the videos. You're absolutely right. a rotator cuff tear can, as long as the motions are the type that would invoke those tendons and muscles, can happen with no weight on the arms, right?
Like trivial amounts of weight,
If
yeah.
there's disease, if there's drugs, I have a rotator cuff tear because I used some medicine for diverticulitis that attacks your tendons, right? So, but I think that the point that you're getting at, it is, everybody needs to be judicious. Adjusters sending a video that is of questionable value, maybe I can use it in trial to fill in the blanks that you just said that we can't get from the video. I got a witness who is the supervisor who saw the trash can and it only had tissue paper in it. Is that relevant? I don't know. Is there, again, pre-existing conditions that might have been more likely the cause of this? If this is something that could have, the injured worker could have been equally exposed to outside of their employment, do you use your arms at home? The fact that you happen to be at work when a tear happens, does it make it compensable? We don't have a standard like in California, which is called a positional risk test. Anything that could have happened to you in your house at California, if it happens at work, it's compensable. That is not the law in Nevada. That doesn't work.
And you have that doctor's interpretation of the MRI that says they already had action.
Correct. It has to be caused.
It's not day one, it's probably day 100.
Right. We don't have a liberal standard of interpretation here. So we were saying earlier to you, doctor, the laws are different in Nevada is its own unique animal that is dramatically different from every other state in this union in terms of how our act works. So being at work and getting hurt is not enough in the state. So, but that isn't going to help you as an adjuster to send a video to the doctor, as he's saying, now I gotta watch this stupid video. All it shows is somebody lifting a trash can. I already knew that. Right? That video does, I'll tell you as your legal counsel, this video does nothing for you as it sits. There is more work that we can do, and then I can maybe use this to demonstrate, again, totality of the circumstances. That's a legal matter. He's not a legal guy. If you're sending him a video that shows the guy not getting injured at all, that might be relevant. But
Yes.
also, it doesn't really go to treatment. Let him do his job, and we'll take the video to court for the trier of fact.
Thank you. Yeah, amazing.
I do have somebody online, Nicole Marley wants to say something. Nicole, can you enable your mic and ask your question?
She might be laughing. I just sent her a text.
All right, go ahead, Nicole.
Question, more of a statement.
Okay?
I think it's important for us to know as adjusters, and I'm speaking to the adjuster staff right now, that in regards to some of the conversation that I was just listening to about, delaying care and potentially not being able to give approval for things that need to be done as a medical, people that are needing surgery, things of that nature, and we're not necessarily wanting to accept it, or we don't know if we're going to accept it or not. Because we just haven't done our full investigation, which we all should be doing at every single step of the way on our first initial contacts.
Absolutely.
There is a thing that I think that we've kind of gotten away from that we used to use all the time, and I've tried to bring it back a little bit with our group. We can approve things under medical necessity to move the claim forward as far as the claimant getting the treatment that they need. But it also protects us in not having to pay for it if we find out that this is not industrial or this is not for us to be paying for under the claim. So I think that we need to reevaluate that in our thought process.
But isn't that before the claim's
As Dr.
accepted?
Sincow said, there's treatment that needs to be done. Well, yeah, there is. I'm sure there is.
Nicole,
But is it a part of the claim?
Nicole, isn't that before the claim is accepted, you do it under medical necessity, not if the claim's accepted, and, that way you'd have to do it under a rule-out basis.
Medical investigation.
Or
versus
medical
medical
investigation
necessity.
versus necessity.
We should be scoping claim before we accept these things. So if there's something that needs treatment and we haven't identified that as part of the scope, and this guy is seriously in pain or he's having issues that are potentially, big enough to cause him further problems in life, then those things should be considered under medical necessity, and the doctor should understand, we don't want to delay this person's care. There is a
So basically what,
Just for those in the back.
so
Well,
what,
give her the microphone. Have her, oh, okay.
I'm
I
gonna
was
let
like, you don't have to, we don't need hearsay.
She's got this, Kevin.
I'm not sure if you guys want mine.
Stay in
all
the
right,
lane.
so this is what I said, the shoulder and the neck are related. So if you have a neck problem, but your neck is still hurting, your shoulder could still be hurting, but the neck is yours. So if you're further into the claim and that neck is still pursuing pain, or with any authorization for that matter, I always put rule out basis only, med necess only, and diagnostic purpose only. So if those diagnostics come back and it's actually the shoulder, well, you don't have to abide that shoulder because you're ruling out the pain, because it's the pain that's causing the neck to hurt and vice versa. That's just an example. But even like in the back with injections, and Cody, you can help me out, so they can do different levels of injections of your back or different types to determine where that pain generator is.
That's a diagnostic point, right? Like facets, like that's what they're trying to do. You can approve that injection to give us therapeutic, hopefully, but at least a diagnostic kind of, yes, we can confirm that's your pain
Yes.
generator or not.
Diagnosis, right? This is what's coming up. So thank you for bringing that up, right? Once again, without a diagnosis, why is this person hurting right now, right? We cannot give a useful causation opinion. So please, however you need to write on the form to get the studies approved, the MRI, the EMG, the whatever, help us out, please, right? Because we're not magicians. We don't know everything just by looking at someone, right? We can get a lot of information from a history, from a physical, from medical records, but it's not always clear if the pain that's somewhere over here is a shoulder or neck. We don't always know, right? And it's not helping anybody if we cannot get the investigative studies we need, diagnostic. Different story with treatment. I guess we don't have to go into that too much right now, but for the sake of finding out what the diagnosis is, let's please not introduce too much friction to that part. Yeah?
Yep,
Can we go to case two?
Case two.
All right. You could probably already tell how this one went by the way it's written, but we had a bus driver who had a slip and fall that's unwitnessed. By the way, it seems like a lot of injuries are unwitnessed, okay? It's just the way it is. Seems like people have a lot of weight. They ascribe a lot of weight to it, but it is what it is, okay? So she says she landed on her hands and knees and then has some knee pain, okay? On the exam, it hurts where she said she fell. And then here's not her x-ray, but a representative x-ray. What I would like to bring in on the medical side is I'd like to have Dr. Debbie Parshad comment a little bit about the x-ray. And, you know, it's advanced arthritis, but there's a question of, did the fall cause all this arthritis to show up? Yes or no, right? Could you?
Yeah, I mean, well, so yeah, the answer is well, no. In the sense of they wouldn't cause it. In the sense of like the arthritis is there. So looking at these X-rays, you know, it's almost bone on bone. There's quite a lot of thinning both in the medial and lateral space, probably even in the patellofemoral space. So this would be someone who has tricompartmental arthritic changes, fairly significant in nature. The question more lies in the clinical presentation, right? I mean, like this X-ray finding shows arthritis. Like those spurs did not develop in 20 minutes, or like, you know, or the thinning of the cartilage did not develop in like an hour, right? That is over years and years to do it. Now, the question is, you know, this concept of like having this dormant pathology and like how much of that is, you know, how much do you portion to that versus that? But I mean, you know, does this patient have any symptoms before? Like, did this patient have any knee injections? Did this patient see, you know, one of the ortho guys because they were having knee pain? Or were they scheduled for a total knee? Like, you know what I mean? Like, again, this is where like some of that, you know, detective work is useful to kind of look at, because clearly I can't argue and sit here and say, well, yeah, that's accident related. I mean, all that arthritis was caused by that, obviously. We can't, but it's about having dormant pathology and how the clinical manifestation was, in the sense of inauguration, you know, precipitation. Like, what is this an inciting event that like created symptom management, and can we get them back to be asymptomatic in some ways, which is what I want, right? Like, I want them to become asymptomatic again. Maybe it's not that hard to do that if we like get through 8 weeks of like, you know, things, and we say, oh, get them PT, maybe a quick shot. Oh, okay, you're back to normal. Okay, see you later. Bye. You know, go back to work. See you later. But
that person was asymptomatic if they're bone on bone. I mean, I could.
Great question.
I'm fine. I never had a problem ever.
Liar, okay, so far.
Realistic that I've ever had a problem?
So to be honest, yes.
Yeah.
Yeah, no. So I've, yeah, no. Correct.
That's a joint.
No, I have seen remarkable images and think, how are you able to walk? Like, I mean, I can only talk about the medical part. I can't, I know to like, maybe someone who's like not in that, you're like thinking that's kind of good, but I have seen joints like almost like dislocated because they have so much erosion, and I'm thinking, and they're here to see me for like a hand in thing, and I'm like, what about your knee that doesn't exist? You know what I mean? Like, I'm like, they're like, I don't have any knee, like, or I'm here for something completely related. So like, you know, like, but I have so many of those occasions that I cannot have that, like, that perception, because I have been wrong too many times that I'm like, looking at an image, I'm like, oh, I'm gonna go see this patient because they're paralyzed, because they have such bad cord compression that I'm gonna see them. And they're coming to see me because like, actually I'm here because of like, you know, this hangnail I have, and I hear you're really good for that, or so, you know, I'm like, you don't have any numbness, tingling, you don't have any weakness, you have no actual, like, and I'm thinking, how is that possible? But that's the art of medicine. Medicine, like law, is the same way. There's a lot of art to it, and like you are surprised every single day. So I can't go in there and like have a pre-notion in my mind thinking, oh my gosh, you know, like this patient had to have this, because it's honestly not true. And like I know Sinkov's like is nodding his head because he's experienced it too, where he probably looks at an MRI, and if you looked at the MRI, you would say, this patient needs surgery, I need to get this patient, send this patient to the emergency room, they need surgery immediately. And then you see them and you're like, you don't need anything. You're like perfectly fine. And that's why it's a combination of things. It's a combination of clinical.
Until the last minute, cancer patients, like, they hit their head and they go to hospital, like, oh yeah, you have stage 5 cancer, stage 4.
Like I had a case. I had a case at Sunrise.
Zero tolerance for pain, so everything hurts.
Like sometimes the oddest thing. Like I had a case. Look, this is a real case. I had a case that came in on Sunday night, so Monday morning when I had an elective case at Sunrise. It was a 20-year-old who was getting a deep tissue massage because she had neck pain. She had a little tweak in her neck from her masseuse, ended up completely a quad within minutes. She came at 4 in the morning. I took her straight to surgery, got an MRI stat, and like you're hearing the event of the mechanism, and you're thinking this patient went for like a nice deep tissue massage because they were having neck pain. I've not seen a case like this. I had to call the neuroradiologist because the MRI was so severe. I was like, am I like missing something here? Like she had a large epidural hematoma from her skull down to T1 with severe cord edema. And I was like, this is like an insane case. By the time I met her, she was completely like zero. She could do nothing. And I took her for like a laminectomy. Luckily, she's, you know, I ran her last night and she's doing much better. She had improvement. But yeah, she can move her legs. Her arms still have deficiencies. But I'm just saying, like you would have never thought that, right? Like if I told you that story and I said, hey, this case is, but there's no doubt in my mind that 100% happened. She went to Summerlin Hospital, transferred to Summerlin, like right after her massage, like it was during the massage that this happened, and you would think that that's impossible, but when I see so many things impossibly happen all the time, you can't sit there and tell me like, oh, are you sure, Dr. D? I'm like, well, I don't know, I've seen it. So
I would love to piggyback off that. You know, there's a misunderstanding sometimes medically that imaging tells the whole story.
Yeah.
It does not, right? In med school, the first thing that was taught to us was 80% of the diagnosis is made with history and physical. Okay, that means no X-ray, no EMG, no nothing, right? The other 20%, I mean, I'm sure the ratio changes by diagnosis, but the point is, it's the totality of all the investigations you've done. Okay, so you cannot substitute an X-ray like this for the interview. Okay, if you don't interview or examine the patient and you only look at this X-ray, you're going to make a lot of stupid assumptions.
That's right.
You're going to be a mediocre physician, actually, right? That's just it, right? You don't want a doctor who only looks at one piece of the puzzle, right?
Because that would say, you need surgery.
Or yeah, you need 2 knee replacements right now, right?
And another thing, just to throw in some legal ease, I guess, in this, claims under the workers' compensation claim in the state of Nevada cannot, per our Supreme Court, be based on possibilities and speculation. Can't be. That's why the medical standard, which comes from a different case, is to a reasonable degree of medical probability, right? So, looking at this in a vacuum, pain is subjective. It absolutely varies from person to person. So this person could, prior to this incident, had been walking around just fine. They also could have been in pain and almost in need of surgery, or knew that they needed surgery and had this legitimate accident at work and then realized, maybe I can go ahead and get this work comp surgery for this knee condition that I got, which is not something I want to see happen as a defense attorney, right?
I think Cody.
In these type of cases, it's so easy to see each side fall to their own place. I see adjusters and go, that's absolutely pre-existing,
to go, don't care if it was there, you got hurt, so we're gonna get everything through, right? I've seen attorneys come from either direction. Personally, the only thing I can think that I can do to advocate for the right treatment and a right determination, I'm gonna see if there's prior studies, I'm gonna see if there's prior medical documentation. If I can show to a doctor, here's what their status was before, they can more clearly say there's a change or there was no change, right? All we can do is give everyone the right information, all of the available information, and I've said to adjusters, in absence of any prior physician notes, any prior imaging studies on that body part, I don't think you have anything here that you can deny.
Thanks, right? So,
Like you have to just collect what you can, give the people who have to make that decision all the information, and then let them in their expertise make that decision either medically or from a claim standpoint.
so Cody and Dalton like touched on this, right? There's a range of possibilities of how this person was before the fall. She could have been jogging, okay, right? This is not medically impossible. This happens, right? People come in, these gnarly looking knees that you would think need surgery, and they're okay. They're here for a hangnail, okay?
Yeah.
Or she's going home every day in tears, ready for surgery scheduled the next day, and had a slip and fall at work. It was like, okay, let me hot potato this over, right?
Right.
I don't have time in my 20-minute office visit to go interrogate, you know, the dysfunctional healthcare system of the U.S. and Nevada to find out all these little details, right? And so in the interest of moving things along, I assume she's telling me the truth and the whole truth, all right? Unless there's a problem with her credibility. Hint. Okay, so why don't we talk a little about how this case went, okay? So slip and fall and knees hurt, okay? So she says that now the knees hurt so much, she can't work full duty. It hurts to drive the bus, it hurts to do. Okay, fine, whatever. Prescribed her some topical meds, okay, just a cream, doesn't want to pick it up. Interesting, okay? It's interesting, but it doesn't convict anyone of anything just because they don't want to use a pain med, okay? That's just something we keep in the back of our head. Okay, so okay, let's go to physical therapy. Doesn't go to physical therapy. Interesting.
Clue two.
I was like, okay, well, maybe I'm not sure anymore. Maybe Dr. Kiak's wrong. This happens, by the way, okay? Maybe it's not symptomatic arthritis. There are other reasons your knee can hurt that have nothing to do with those x-rays, right? This totally happens. So like, oh, let's get some MRIs. This time the patient actually told me, I don't want any of this stuff, right? Not the adjusters, the patient didn't want it. And then she, after I go to her a little bit more, she says, okay, I'll go get the med, but my boss doesn't let me put on this cream on my knees. Interesting, okay, we've covered 5 patient behaviors so far. What does the audience think of this patient as of right now?
Secondary game.
Little sketchy, right? What you could probably say is this is a fairly non-compliant patient. That's the magic word. This does not mean the patient is fraudulent, okay? Non-compliance does not mean fraudulent, okay? So at this stage, this is not a very sympathetic patient. Okay? I'm not really having a good time here dealing with all this nonsense. But I also don't have any basis to go flip the case over and say, all right, you're out of here, right? That's not how it works.
That's the way you do it?
Oh, yeah.
Out of here.
I'm a drama king.
I didn't think that was the way this happened.
Yeah. I want to repeat this for the audience because, listen, no one likes a non-compliant patient, okay? And non-compliant itself can be a pretty harsh word, right? Sometimes people forget, don't know, or overwhelmed, not educated, language barrier, blah, 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 blah. It could be a range of I don't know how to help myself versus I don't want to help myself, right? And no matter which end of the range that is, that's not enough to say the patient has no injury, I'm not going to treat this, right? That's not fair. Okay, let's go on to the next numbers. So I asked her, okay, what happened to your PT? Why are they all canceled? And she says, well, I didn't miss a single one. Interesting. So I channel my inner med student, which watched a lot of Jerry Springer on my surgery rotations. Watched a lot of Maury, a lot of Jerry Springer, right? I hid from the OR. I hated surgery. Okay? So I would go hide with the patients doing post-op care, right? Bandage, dressing changes or whatever. I go watch these trashy daytime TV shows with them, okay? And boom, I don't have a lie detector, but I have something pretty close. I have a PT attendance log, right? And I have the physical therapy clinic on speed dial. So I said, lady, you know, this is pretty hard to believe because I'm being told right now, you are telling me you didn't miss a single one, right? Is this, like, are you sure? Like, she's like, yeah, I missed any of them. Okay, boom, speakerphone, call physical therapy. I have the insurance provided PT attendance log. And the lady says, yeah, you did in fact miss like 3 or 4 of them, you cancel all of them. She's just flipping out, you can't do that to me, she's pretty much ready to storm out, and she dropped behind this pre-filled long-term disability paperwork with some date of injury, I don't know when, it's like, you know, a long time ago, just wait for me to not pay attention to and sign off on, right? Okay, what do we have here? Between points 6, 7, and 8, I would say the patient now has a credibility problem, right? And I am not a lawyer, right? It's not my job to cross-examine the patient and determine their credibility, but it does come into play medically, because if the patient cannot be relied on to tell the truth, you are in a dangerous zone as a physician, because you're treating a ghost, right? Like, if I cannot ask the patient to reliably communicate what body part hurts and how did it happen, this is pretty dangerous. Now we have to convert ourselves to veterinarians, right? We have to interview other sources, right? We have to look at medical records.
A dog
right?
can tell you.
We have to ask collateral, right? This comes up in psychiatry all the time, right? In psychiatry, you have patients who are unreliable by definition, right? They're hallucinating. They don't know which way is up, okay? If you, the doc, take these patients in an acute psychotic episode at face value and do not ask the family what's going on, do not review medical records, and you just take them as credible as they are, you are a bad doctor, yeah? So, once we got to point 6, 7, or 8, this is what I did, and I'm sure this will invite a lot of controversy, right? But I sort of had too much evidence now on my little scales of justice, or whatever you want to call it, where I had too many doubts about the credibility or the reliability of this person. Did she actually fall? I don't even know anymore, right? If she is so confident in telling me that she didn't miss any PT visits, and then had 4 missed visits, and then she has this pre-filled date of injury that's wildly incorrect, right? Is she lying? Is she demented? Right? Maybe she's not lying. Maybe she's actually demented. Yes, this can happen, right? But there's something not quite right. And at this point, what I did with this case, I said, okay, I don't know if anything she said is true or not, unfortunately, so I reversed my causation opinion. What does everyone else here think of that?
So I think that, you know, we all have to be doctors or scientists at core. You have to be willing to change your opinion as new evidence presents itself, right? So the only thing I want to add to what you've said is there's a couple of legally consequential occurrences for the purposes of the statute and adjusters. Somebody refuses to treat. We use in the Act, you know, the Nevada Industrial Insurance Act goes back to 1913. Unsanitary practices, so old-timey unsanitary, injurious practices, which the doctors, again, they're looking at that and they call that a non-compliant patient. The Act calls it somebody who's being unsanitary because they're not again, that's very old nomenclature for that kind of thing, but that's what it is in the Act. So you're going to shut them down. If they're not going to treat, we're not here to play games. You're supposed to have an industrial injury, and we're supposed to be getting you back to work. If you're not going to do your stuff, we turn off the spigot. And so that's something that's going to happen on that side. Once it gets into a doctor deciding that somebody's malingering, well, at that point, we may also refer them to the AG, right? Because now we've got actual fraud going on. And that's outside of everybody's pay grade over here, except for Kevin Dills and some criminal stuff. I do defend an occasional insurer or employer who had a lapse in insurance or what have you. It's a Class D felony for employers not to have workers' comp insurance. It's also a Class D felony to commit fraud under the system. So a couple of things that come up. But again, the doctor's not a lawyer or a judge or anything else. He's just a guy who's trying to provide some treatment to a patient.
Well, and let me give you then, so if you like inject me as in say I represented this hypothetical client. Now, I love the point that Dr. Kiak made is that non-compliance is not fraud. Okay, I mean, it's actually quite different. But because fraud is actually a crime, not attending an appointment, I mean, even if the reason is BS, that's not a crime, okay? I mean, it may certainly put your future benefits in jeopardy, right or wrong, what have you, but it's not a crime. And I always find, that we are quick, okay, to send out this. And by the way, your little 10-day letters, there's nothing in the statute that says we have to do anything in 10 days, okay? And by the time if you're not serving documents properly, which some of you are not, via fax, and you're mailing that letter, okay, I'm getting it 5 days later, and all of a sudden we're supposed to do what you say in 4 or 5 days, all those types of things. But I just, yes, there's people that miss appointments or have you, but usually there is a good reason. But if I represent this person, so the reality is, what the question posed was, what do I think about the doctor changing the causation opinion? I'm not even going to comment on that because I wouldn't, if this person, I represented them, I have a job to do, okay? So that's the thing too, is that, can I think, I mean, you mentioned I do criminal law. Do you think I think some of my criminal law clients are full of shit? But does it matter? I mean, does it matter? And if I really feel that way, and if it would impact my representation, then I have to go, okay? So this is not a case I would take, okay, for a host of reasons, but let's just say I did, okay? Non-compliance for us is a real problem, okay? Because my job as a lawyer is to obtain all the benefits that we believe that they're legally entitled to, okay? If you're not going to treat, there's not a lot we can do. And I don't work for free. So if you're not going to treat on this type of injury, there's likely no PPD. So I would get out, and if I find out, and that's the whole thing is that if clients lie to me, like Dr. Kiak is talking about credibility from the patient, okay, it's also very different from attorney-client, okay? If they are not communicating with me, you get about one time, okay? Because I have ethical responsibilities that if there's a communication background or if I don't believe them or if I don't do any of that, it really falls back on me. What do I need to do professionally? And most likely, if I still have this case, I will have to just simply withdraw, okay? That doesn't mean I give my opinion on the way out or do anything on the way out, but so it's very different where my job as a plaintiff's counsel is literally what I would ethically have to do is just simply withdraw from the case. So, again, it depends upon who you're talking to and what their obligation is. And I think it's very interesting to see what everybody's separate distinct obligations are when you have actual real facts in an actual real case.
As a claims adjuster, him changing his opinion on causation does nothing for me. I've already accepted that claim.
That's right.
So you changing your opinion muddies the water. Say that you have nothing medically further to offer this patient, and then I can do something with it. But changing your compensability decision, I can't.
Well, so I changed the causation opinion. I didn't change the right? It's not my job to do.
Your causation determined my compensability.
Sure, but the problem is causation, right? As we know, always comes with uncertainty, right? We are never 100% certain of the diagnosis or the mechanism or the whatever. Whoever's seen my notes always sees I got a little blurb in there that I reserve the right to change the opinion as new facts come to light. Because that's what happens, right? We get medical records.
But I can't deny the claim.
Oh, well, sorry. Well, okay.
You can't do a darn thing with that statement.
Sounds like you need Dalton.
You could just say that I have nothing further medically to offer this patient. Okay.
Okay.
Then we can do something with that, right? Or you can refer her to a second opinion, or you can do other things.
I do see that a lot. I do see when the doctor is presented with a case like you just said, a lot of times they'll say, I have nothing left to offer,
Learning point for me.
Second opinion. And I see that a lot, particularly on the back surgeons too, where the patient is pushing for back surgery and the doctors are like,
Yeah, but the writings.
What happens a lot of times is our patients come in with this horrible back pain and horrible back injury, and then they'll come in and do an act, like the walker, the
Oh,
shuffle.
we're going to talk about this. Is this coming up next?
All the accoutrements.
So, our both doctors do a full exam, and they're like, okay, this
thank you for mentioning that, because this brings me to my very next, oh, sorry, is there someone? Oh, I'm sorry.
Get here, to the checkout, to the baggage.
The patient needs something, but the adjusters keep denying because they don't want to pay for it if it's a higher value procedure.
You call their supervisor?
So,
It ain't about money for the adjusters, and if you guys as adjusters think it's about money, then, you know, we need to talk about alternative employment. Because
Drag out
it's
the
not
case,
about the money.
She needs this just to be
Right.
better and go back to work.
Right,
You're
it's about the money in
dragging
the
it out.
sense that we have a fiduciary purpose, that we have to adjudicate claims legally and within the boundaries, and we do get in trouble if we go crazy with them, et cetera. We also have to justify every single dollar we put on there. So if you call me and you send that patient out with the latest and greatest RX, and it's $5,000 a month, and there's an old one that used to be $200 a month, we are gonna push for the 200 because we have a fiduciary responsibility. It's not about, our focus is on money because that's what we do. We manage an insurance policy within the boundaries of the statutes and law with the information provided by these geniuses, all of them, and put a dollar on it. So earlier we were talking about expanding scope. When you talk about injections, that takes a claim from no PPD to a PPD. A PPD, I just saw one yesterday, $212,000. So for me to hit my client and say, hey, you know what, he was complaining of pain and now we have injections and so it's a $200,000 claim now, that's a challenge for us. So when you get in defense for all of us as administrators, we do bitch about money and we do push back about money because when we raise it $1, there's a whole lot of people that come down to us and ask us what that's about.
And I think as an employer, it's frustrating to see the FMLA where somebody can come back to work the next day, but if it's workers' comp, you won't see them for 6 months. What about that, doctor?
How about the hockey guy? The hockey guy, 6 weeks, he's back to playing hockey.
What about that? I mean, and this is the same person.
There's plenty of
Shoulder
studies
surgery,
that
back
show
to
that.
work.
Yep.
Work comp shoulder surgery,
bad outcomes.
still
I
on
just had
board.
an amazing conversation with this fine guy.
No
and-
PT versus, oh my
Yeah.
God,
You
4 months
can't-
of PT.
Yeah, it's
Why
it's
is this
experience.
fair?
Let's,
So,
let's
let's-
move on and run out of time.
Let's get in, I really want to get to the third case, because I think
Okay,
everyone needs to
do
hear it, right? So, there's a lot of F words been thrown around so far, right? Fiduciary, felony, fraud, right? I've heard a lot of them. The most pertinent one hasn't come up yet. Faking it, yeah, who says this?
No.
No, it's all, you don't know how many times I get these all,
It's from Louisiana.
yeah, y'all, meaning, all, you know, you guys and all y'all, okay? Yeah, right?
It's not us.
I'm kidding. Okay, so look, I understand there is concern, right? There is a fiduciary duty. Yes, okay, this is a societal thing, right? We cannot just be throwing money into everything. There's not an unlimited resource. We don't have unlimited resources, right? So it's in everyone's interest that we don't perpetuate nonsense, right? But let's define the F word, faking it, okay? Because this doesn't mean what you think it means, okay? So what's this guy doing? Did he or did he not twist his ankle? Did he or did he not hit somebody? Maybe. I don't know. Right.
Acting is what it's called.
Yeah. Or maybe it's called symptom magnification, right? This guy was on national TV striking with some variable degree of force the shin of the other soccer player, and he's over here hooting and hollering, okay? We would call that in medicine symptom magnification, right? When there's sort of this mismatch between the subjective complaint, right? I bumped, I touched a shoulder, and I'm screaming with 10 out of 10 pain, okay? Maybe, is that what you mean when you say you're faking it, right? I want y'all to be specific, right? Don't just say faking it. That's not helpful, right? If you think he's magnifying symptoms, okay, let me know. Other times, Dr. Keon, he put shoulder on the C4, and you know, there's all this other stuff going on now. Medically, there are a lot of fascinating reasons for why someone can have a shoulder injury that isn't a shoulder injury, right? These are some of the juicy ones, right? Conversion disorder, somatic symptom disorder, this is a case of mind over body, right? people who are extremely mentally distressed or have some kind of something going on upstairs, yes, they can genuinely feel like their shoulder is causing, something, right? And are they lying? Are they trying to pull one over you? Are they trying to take you for a ride? Maybe not, right? I wouldn't assume the worst intentions, or no, I would. Please don't assume the worst intentions of your claimants, our patients, your clients, right? That's just such a nasty way to approach somebody, right? If you go to your doc, you're like, hey, doc, my hair's been falling out. Are you sure? That's nasty, okay? Let's not, if you wouldn't want that own behavior from your personal doc, don't impose it on the people that you represent, yeah? Okay. Other things that come up, right? We don't need to get too much into this, but there's a lot of non-fraudulent reasons for some of this stuff to come up, right? Here's one that's already been covered a little bit, right? Wrong body part. I cannot tell you how many foot sprains have landed in my clinic from a chain of clinics in town that was actually, that someone's hunting vigorously, right? And guess what? It's the wrong diagnosis, yeah? Yeah, it's not a foot sprain, right? If you have a back injury, you can have foot pain. And if you, as the physician, fail to consider all the other pieces, you're like, well, he says his foot hurts, and I'm only gonna talk about the foot. Anything above the ankle, I'm not gonna talk about. Congrats, you're a bad doc, right? You deserve to get disbarred by that guy, right? Okay, so when some of these transfers of care land in my office, right, I am asking, right, okay, what else besides your foot hurts? Does your back hurt? Does it worsen when you bend forward? Blah, 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 blah. And then when I do my whole exam, I'm like, uh-oh, something's cooking. I think I need an MRI, right? That's how we get to that point. That's how a foot sprain turned into lumbar radiculopathy. How a 0%, whatever, PPD turned into something maybe injectable, very expensive. Yes, I know it sucks. It sucks for the patient too. They've been running around for 6 months with a foot sprain that never got better because it wasn't a foot sprain. Everyone's pointing the finger at them and saying, you're faking it, how are you not better, right? It's not the patient's fault. Why would they know, right? Be gracious here, right? When this sort of situation comes up, I'm welcome to a phone call, right? Chat with me. I'll happily explain myself if it's not clear enough in the report, right? No, before you go deny, and drag this out into 2 years litigation, right? If it's a simple fact of I don't know how this happened.
Send you a letter.
Okay, sure, whatever, right? I'm happy to chat. I'm happy to explain this, right? I'm happy to explain how we got from a foot sprain to a lumbar radiculopathy, right? This just happens so often. You would not believe how often this happens, okay?
And can I, just real quick, I'll go fast. Look, take Ann's advice, but I want to be clear. It's not illegal for you to call a doctor's office. You're required to keep a log. If you call, you must put it in the log. Ann's point is simply this. If you have a phone conversation that's not recorded, there's no documentation, it's problematic. It doesn't mean that it's illegal.
I document all the calls,
A doctor's
by the way.
office will call you. Oftentimes in the course of litigation, Kevin's office might call the doctor's office. We might be directed to by the judge, where's the IME report, doctor? We've been waiting for 6 months. Can you call and move that along? So the point is, Ann's advice is great, take it. But if you do, put it in the law. Thank you.
And my, and my is kind of when I led the discussion this morning, or the question I opened up to people is that, do you really believe, okay, that it is appropriate and or ethical, okay, for anyone from an insurance company or an employer, no matter what, to, in my view, call the doctor's office to provide them, again, they're not the trier of fact. So to provide them all of this information, okay, because, I mean, what I think that is steering the medical opinion. Now, certainly that's debatable or what have you, but.
It isn't. If you're going to steer in a letter, it's still just wrong. We don't want you steering ever.
Right. I mean, you just ask the direct questions, because if you steer it in any way, or mislead the doctor, or even mislead the doctor and here's bits of pieces and walk them into the law that's not properly set out because you're not a lawyer, it doesn't work. And yes, it does extend things. But that's my question that I pose to you as an ethical challenge, is that should you really be contacting them at all. I don't do it. I just don't. Doesn't mean, again, I don't speak for every single plaintiff's attorney in the state of Nevada or the whole United States, but I just don't do it because I don't, and I'm friends with some of them. I mean, like, some of them in the same Jewish community and all that, but I don't do it because give me your opinion. It's not appropriate for me. And if I need to give you other facts, well, okay, but is that, and will it help the medical opinion? Will it not? But yeah, that's going to come in writing. I'm going to copy the other side. I'm going to do all of that. I love these IMAs, the insurers sign up, but we have no idea what the questions they ask the doctor, okay? That will come up in litigation, okay? But I just always believe that no insurer or employer should be contacting a physician to provide, like what he was talking about, these facts that, does that mean they're going to stop caring for them? And you're hearing the answer down here.
Thank you for bringing this up. I want you to put your ethics hats on for this next case because it's messed up.
Let it fly through it in 6 minutes.
That's fine. So look, we have a 41-year-old foreman. Right? He shows up to my clinic as a referral. Says he was rearing in a work truck. Right? Neck pain, headache, blurry vision, flashes, and floaters. Okay. So if you're a good doc, you're gonna be on red alert mode for something emergent, okay, right? There is a potential time-sensitive problem based on this complaint alone, okay? I have almost no eye examination equipment in my clinic, but because of the story, I have to rule out extremely time-sensitive stuff in the back of his eye that could result in blindness, okay? So, here's what happened. He actually had a retinal tear, okay? And this is something that needs to be acted on in hours to days, okay? Doesn't have time for trial, doesn't have time for whatever, okay? It doesn't have time for all of this, okay? It needs to be acted on quickly. What happened was someone showed up to my clinic and was like, Dr. Kia, by the way, did you know he was the one who caused the accident when this happened? Dude, what does this have to do with anything, right? Like, I'm not a lawyer, okay? I'm not writing this guy a traffic ticket, okay? I'm opining on whether or not a rear-end car accident could or could not cause a retinal tear. By the way, the answer is yes, okay? So, the second helpful opinion from this person was, well, I'd never heard of that before. Thank God you're not a doctor. Yeah? Hey, this is what happens when you practice medicine without a license. This guy would be blind. Yes, blind, B-L-I-N-D, thanks to your not staying in your lane, okay? What happened with this case is someone hit the rubber stamp, deny, and I had to go call the retina docs myself and argue them on the phone. Said, I'm going to put it in the chart that you refuse to see potential time-sensitive emergency, right, if you don't do this right now, okay? So they did. Saw him the next morning, had surgery that same morning, okay? So why did I bring this up, right? This came up because this is a real case, right? This is a productive member of society. He's got a family, he's got kids, he's got a wife, he's a foreman, right? He's contributing to society. And I am not sure what the purpose of all these, I don't know, ex parte community, whatever. This person is represented, thank God, okay? What would have happened if I took this denial at face value? Oh, I guess someone doesn't think the retinal tear was caused by the car accident. Well, who? My license is gone. Okay, that guy is coming to get me. Okay, you'll never see me again. Right? So when we need investigations, when we need diagnoses, when we need to get an answer, please do not delay. This is what potentially can happen, right? Is that someone can just go blind, right? And yeah, that's on you, right? Yeah, you didn't. You didn't. You weren't the doctor in the room. You didn't deny the treatment. You denied payment. You created a ton of roadblocks for care, right? That's the consequence of your action. Please do not do that, right? If the situation were ever flipped and you're the one in the car accident, okay? Work or on the clock, not on the clock, does it matter? Come on, seriously, no. And the first thing you get to the ER is they're like, well, I don't know if you were, did you have your seatbelt on, or are you sure it was a red light, right? And they're arguing with you about that instead of, hi, let's take a look at your eyeball and figure out what's going on, right? You don't want that happening to you, right? So I don't want to get too much more into this, except that this is a real case that's ongoing in my clinic right now, and it's actually in litigation. They're still arguing with me, right? Why? I would like to ask the room why.
Well, I can answer the question why. This is, and I know that we're going to get a very different opinion. Look, you just said everybody has to stay in their lane. This case, in my opinion, from what I've heard, I don't know any other facts than what I've just heard today, went down almost exactly how it should have. You, the doctor, said, I don't care whether it's an accepted claim or not. This is an emergency. This man needs treatment now. We can sort out who's paying for it later. That's the only question that's being presented. If the adjuster says, this is a weird circumstance, I don't know why he's got an eye injury from this, and concludes that the claim has to be denied, or again, we've already heard some proactive solutions for adjusters. Accepted under medical investigation on a rule-out basis to determine what's going on. That gives them the ability. But if it's denied and that adjuster firmly believes that it was properly denied, and there's good people who are going to have to make that call that will be making that call, and it's not necessarily a bad thing, it happens. The Act understands that there are going to be circumstances where life and limb are on the line, and it's accounted for. You say it's an emergency, they get the treatment, it's over, we'll sort out the pieces later.
Unfortunately, while I agree with you at face value, right, that technically, if it's an emergency, it needs to be treated. In reality, what happens is there's a lot of barriers that it introduces when there's a question of who's going to pay for it, right? People love stiffing doctors. Okay, I get stiffed or attempted to be stiffed all the time, right? We cannot run a practice making no money, right? And so when there's a question of this may or may not get paid for, but you need to take the risk of doing emergency surgery, having it go sideways, getting sued for it going sideways.
Yeah,
by the way, we're not going to pay you because I don't know. I didn't like the way the guy talked to me on the phone, right? This is not fair. That's extremely unfair, right? And once again, the question is, what are you trying to accomplish here, right? I'd rather you pick up the phone or issue a letter, right? Or I try to pick up the phone sometimes and chit chat, right? Say, hi, I have a potential emergency. Can you please just approve this stuff right now, right? Or, under whatever investigation, necessity thing you need to. And if it turns out the guy was lying, he was off the clock, right? Can that not be sorted out in court later while he still has his vision?
No, that's what we're saying. If they accept the claim, it's compensable.
Not even under medical necessity.
That's a decision that goes away. So
that's a shame.
Well, no,
look,
in this case, no. I mean, what they should have had is you just said that there's emergent circumstances. So you can put language in there, just what she was saying back there. We're paying for it on a rule-out basis. Sure. We'll get a medical opinion after the fact, so they wouldn't just own it. But, I mean, even like things that are a serious emergency, I'm in court fighting for them to pay the bills and things like that. So there are ways around it. Unfortunately, I rarely see it. And I rarely see things done on a rule-out, which that helps us too, because you get an opinion, especially when you have another specialist saying, oh, that shoulder neck thing that happens a lot. I'm in court all the time because we're like, just give us a consult for the shoulder, or just give it, and all that. You can just quickly rule that out, and it just isn't done. And so that is an industry issue, but it is. I mean, but
It really was standard.
And it worked well.
I mean, I have a client who, same age as me, okay, she's a nurse, and horrific kind of inhalation injury that ended up expanding even greater than anybody had imagined. They actually didn't fight us on all kinds of things you can imagine, the joints being replaced and things like that. Well, okay, she's on oxygen, okay, and it's for, they accept it ongoing, for life, whatever. Well, oxygen tank is empty, okay, or not operating properly. I guess the vendor changed or something like that. So goes to say, all right, well, this is what's going on. Vendor's like, well, we're not the vendor anymore because employer got bought out or something again. Like, well, it happens. But they're like, you need to call who? The third-party administrator to find out who the vendor is. Guess who we can't get a hold of? And I said, she's going to end up in the ER. And yeah, you're paying for it. But I just was like, this is so, like, what do you do? Now, these are extreme examples, but you do need to hear these because it is just, I just see so many people, especially if they've been in the industry for a long time, and I don't see it because I don't do claims, but just jaded And they expect doctors to just fall in line with them, and they'll test it out to be like, okay, are they going to be able to, will they kind of fall in line with one of my little, oh yeah, this person's faking it, and this is kind of what we wanted, well, no. And same thing, you're a nurse case manager, same thing, you have a license. So if you fall into this category where you're not a patient advocate, I mean, I don't care what the answer is, but if you're not a patient advocate, you have a license. And you really have no business then, advocating for clients as a nurse either. I always kind of like having nurse case managers. I'd rather have that than an adjuster making a medical decision. But I've certainly caught literally some nurse case managers doing this, showing up and be like, well, this is really the story. I haven't ever heard of that. Thanks. But so that's, some issues.
Right, and I think that as we wrap this up, because we are, I think that you can tell by the way we had a great conversation that this is the beginning of a claim, and there's a lot of things to look at. And I think the takeaways, like Dr. Kios has put up there, the medical opinion is by the doctor. And, I've told this story before. There used to be a pain management doctor here who used to do injections on everybody, including the dog. So I was a baby in the industry, and I wrote him a letter that says, apparently you like money because you shoot everybody, including the dog. Now, that was back when we did have bad faith, and the next day I had no assets because they were frozen. Because that doctor was very used to people challenging him, and he filed a bad faith on me immediately. Now, luckily, my boss was Chuck Berry at the time, who said, you're a dumbass, Ann. And he went back to the doctor and said, she's a dumbass, I can't. I ran a fix her. And so they were able to get that undone. And as a result, we don't have bad faith anymore, and we have benefit penalties, which are really done on a different way. But I want you to really think about bad faith for a minute in every angle of it. Whether it is an adjuster leading, judging, directing, making capricious decisions, whether it's a physician who is not looking at the best for their patient, or whether it's an attorney who is beating our ass to expand scope to include the PPD, to make the PPD bigger. All of those are realities in our business, but it doesn't mean that anybody in their own position should change what you do. Be proud of what you do it with integrity so you can sleep at night, and most importantly, so you can defend yourself on that 25-hour deposition.
Amen.
That's going to come to you when they ask, who are you to make that decision? And that's what I want you to think of when you're writing, not calling. Who are you to make that decision? Don't lead, don't steer, don't do any of that stuff.
If everybody puts their best foot forward.
And it's hard. And when you talk,
whoever's not doing their job is
and when we
gonna
talk
show.
about,
The
and when we
doctor's
talk
gotta
about the jaded and all of that, I get it. I can, the other day I was sitting in a meeting and an individual was calling me, blowing my phone up, and actually right now has life threats against me and is stalking me, etc., because he was picking his face and got in a car accident, and now wants it to support him the rest of his life because he makes more money on comp than he wouldn't have. Now, that versus the other phone call I'm getting because a guy is getting paralyzed because he's got this injury or that injury. Take every claim as a claim. Do your job. Don't do anybody else's job. Do your job, and do your job to the ability to be able to defend it when you're called to it, whether it's your client, whether it's your excess carrier, whether it's your boss, your supervisor, whether it's that client or that injured worker. Just be kind. Let's do some raffles. Thank you, guys. I appreciate you all so much.
I'm gonna open up the chat line online. If you guys have any questions online.
There's my plug.
Text me with it.
There's my plug.
Please write them in the chat line and I will have.
You got little heart stickers, daughter?
Yeah, I got 2 daughters and a wife, and I think my daughter put that on there. Yeah, so that's one of them right there, actually. So.
Aw, cute.
Yeah. All women in my house.
Well done.
Monopolize the medical side.
Yeah, no worries.
You guys
You're in the.
online, please know that they do have a bag of beer, so you can win as
Good job,
well.
country.
Yes, everybody over
I feel like I lost it.
Purchase raffle tickets? Too late.
I got
You know, we should have lunch. We should talk out some of these things.
No, absolutely.
Need to understand sort of everyone's perspective.
Yeah, it's, no, your point is well taken. The only thing I would, ultimately, it is a question of who's paying for it. So we gotta get the treatment.
And if the law is written in a way that disadvantages everybody, you know, legislate it away, because this creates a perverse incentive to maybe deny first, figure out later. But in this case, deny first, figure out later, everyone loses.
Okay, so I'm just
Yeah,
gonna
it's you know, the act is long, and the act is long, you gotta know the 3 parts of the, you got 16 ABCD, as well as the code. It's a ridiculous amount of stuff. But the act is the result of, it's one of the best laws that we probably have in the state, in my opinion. It's the result of months-long symposium. It wasn't written like normal. When they did the reform, it was done by committee over months.
I did a little bathroom break.
So I really do think it worked exactly how it's supposed to. You got somebody who's got an emergent condition, get them the treatment. We'll figure out who pays later.
That's a lot of raffles.
The other side of that, I get you're stuck in the middle on who's going to get it. If it's ultimately found to be our claim, it's the insurer's responsibility. If it's not, these are working people. Many of them already have insurance.
Some.
Just what tranche is it coming out of?
Yeah.
But nobody, there's no name on it. All right.
I wish this barrier didn't exist.
$50.
It puts me in a very scary situation.
I'm not even
The only way to make it not exist is the way they do in other states, which is to introduce
winning
liens,
number
which then becomes its own nightmare.
You can give me, Chris, you seal.
Let me get your number. I can always send you a text.
Yeah, please do.
And Doc, I thought you had sent me a text before, but I don't see anything indicating that you have. So let's do this.
Let me make sure I have your number.
Winner is Jessica Cramp.
Send me a text. Let me make sure.
Can you write these down?
I'll take it because I'm mine.
Oh, will you?
I will.
Jessica,
About a month later.
Yeah, exactly.
That's county.
Well, I just wasn't
Whoops.
sure.
We have a $25 TJ Maxx gift
Yeah,
card from
why couldn't I
Public
find-
Specialist.
Do you have it?
The winner is 315.
I just now got the text from you.
Oh, perfect.
Okay, I just need to change this. Your name.
Yeah, it's a weird area from the middle of nowhere.
No, I did a search, like Apple sucks now. I did a search in my text, because I don't delete them. We got them all going back to like literally
Yeah.
first iPhone. So, and I searched for your name, I searched for Matthew, nothing came up.
That's all
Weird.
good.
It's just not as good
Well,
as
it's my fault for not reaching out too.
No, you're fine.
Next one is a $25 Buffalo Wild Wings gift card from Bone and Joint Specialist. The winner is Laurie Mull.
All right.
Sweet.
We'll be able to give 3 wings.
I know, but Buffalo's crazy. Well, no, that'll be a much bill.
It is.
This one is a $50 BJ's gift card from Cancer Surgery Specialist of Nevada. The winner is Merrick Rivera.
Yeah, that makes you big cookie.
The next one is a $50 Target gift card from Kelly Hawkins Physical Therapy. Winning number 315312.
That's me.
Yay! All right, our next one is a $25 Ulta gift card from Hand Center of Nevada. Winning number is Shawnee.
Oh, it's gonna destroy my protection. And
Okay, Shawnee.
Yeah, I would need to do a contract actually. But I mean, he can write code, he can.
I have one
The next one is a $50 gift card from Dr. Gary Morris for Home
I have one on
Depot.
iOS.
Winning number 315386. 386?
I got it.
I needed that one too.
And what did Johnny Baxter win?
Like right when it
Sure,
came
all
out. So
the
they put me in the alpha. I got stuff that I I've got an app to do that.
Winning number 315386. Going once?
That one is probably first.
Twice?
He lost her. He got it.
Oh, no. Okay, the winning number for Dr.
hurts.
I think
My
what it's
shoulder
going to
hurts
do
from
is
pointing over
be
here.
in the short term for you guys. I think it's going to help you consider Lyme disease where you didn't before, right?
The
For
winner
us,
is Bernadette Gerlin.
Watson for a decade has been putting young associates out of work because it can correlate, reams of. Now it can literally take those and turn into a timeline and then
Winning number
we're writing.
sorry,
So those
315-323.
No, wrong number.
323.
I agree. Dusty?
There'll certainly be an adapt or die,
Maybe not the wrong number.
mentality that's correct. You either figure out how to make it work with you. It will work without you.
We've even integrated that AI in my clinic now, so now I have it listens to my conversation with the patient and generates the care plan.
Oh, lovely.
And generates the.
generates the care.
Yeah, I don't even know where it's at.
Yeah. And then you just sign off on it.
Yeah, it's got some quirks. I have a meeting with the CEO because it doesn't like interpret imaging as well, so I have to add that in, so it's annoying. But I mean, it's got like the vision to do those types of things, which I think from a legal perspective, I'm like, AI is not going to trick you. I'm like, you didn't tell me about that. I'm like, well, I don't know this AI, but thought I did.
$50 Amazon gift card from Dr. Ed Evangelista.
I'm gonna listen. What am I doing?
Winning number
Surgery.
315-325.
No.
I've got 12 o'clock place.
Every time I see you, Cody.
Right here.
Yeah.
Oh, thanks. All right.
I sent you a message.
Oh, great. We'd love to have lunch or something sometime.
Thank you, doctor.
Yes, sir.
So appreciate it.
This next one is a $25 Victoria's Secret gift card.
Oh, that's definitely the one I want to win.
Sabrina Walker.
Yes, Sabrina. That's right. Woo, woo. I can.
Oh, you can take that one, right? You can take Jessica Krabs too, but if you're gonna. I'll talk about it.
Cause I'm not going to the county.
All right, our next one is a $50 Lowe's gift card from Dr. Rod Perry. Winning number 315-383.
Yes.
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 That is Lowe's.
That's right. I can finish that bathroom. I've been working on it for a year.
We have a
Yeah, I met some of your associate attorneys at the CPK event.
$25
Oh, they did?
from
That's funny.
Voc Rehab,
So
Capital Voc Consulting.
they're,
Winning
I guess,
number
my age then, right? They're in their late
315-287.
20s, early 30s.
287.
What a grind, I'm not gonna lie.
Emily, use
It's
it fast.
law is in. So for us, like
Make
you said,
sure you
it's
use it
adaptive.
fast, Emily.
This is what time it is. It's adapt or change, and every time you have a big shift like this, there are winners
Gift
and
card
losers. It's usually
315-417.
not the first actors that like
417.
Google wasn't like the first
Yay, you can be more beautiful.
dog pile and all this other stuff. So it's right now, right, you're building. It's the Wild Wild West.
Sure.
And I absolutely do not intend to get left behind. So I've got some.
Rosie Cuevas.
I've got some thoughts and some things I'm working on.
Yeah.
But I'm stunned that he already has AI.
Same. Well, I guess technology progresses faster than legislation, right? So, and what I'm wondering is how much legislative inertia will protect some of these roles and jobs versus
Winning person, Tina Berglund.
like Uber's
In my opinion, it really, like for law firms,
We're killing it.
it's not, the legislature isn't going, like, okay, so the folks at the top, like for me, I've been saying for more than a decade, I want a team full of robot lawyers, right? Because the drudgery, reviewing medical records, filling out the pertinent facts, writing the brief, which I enjoy writing.
Sure.
But if I can hit a button and then go to court and argue,
I would love the same thing. I don't want to go through 1,000 pages of DS. My conflict comes to the point where I'm cynical in the sense of it's harder, it's easier to sue a human with a license than it is to sue a software program, right? Or who gets sued when something bad happens. In a case of joint
you're exactly right.
decision.
Well, I mean, you can look at it from cars, right? I got two robot cars at home, right? I've got a Model 3 Performance and my wife has a Model Y. They're both on full self-driving beta. We've been on them since it launched. Sometime in the not too distant future, we'll have two 24-hour robo-taxis, right? That'll be able to drive us wherever we want to go. So right now, I'm responsible, right? If the car crashes into somebody while I've got full self-driving on, it's in beta, it's me.
Winning is Kim
But when that
Beasley.
switch is flipped, Tesla wrestler assumes that responsibility.
Right.
That's their liability, so
So I wonder what's happening with physicians, right? Because is there a point where our clinical, no, we're always touching the drug in some way, right? We're not, I don't think we're close to AI replacing all of it, but we are certainly already at the cusp of AI participating.
when I had my resection for diverticulitis, the doctor used, what's the big robot?
Yeah, Da Vinci.
Da Vinci.
Da Vinci, yep.
And they're automating Da Vinci now. Boom, push a button.
Right. And so how does that come in when something sideways happens, right?
Right?
So,
That's where the law will have to keep up. What I was going to say in response to your question is, I think around the edges, it doesn't matter because I'm right now making decisions on how many new lawyers I need to hire based on the technology. So those jobs are gone. Nobody's going to regulate that away.
A
Sure.
Coach
Thank you.
Purse from
Oh, awesome.
Billy Marie Morrison, CPK Law.
Wow.
It's a Coach Person wallet with some goodies inside.
Yeah, let's get some food. We'll have a great discussion around this.
Claim number is 315297.
No.
We thank you guys
no, that sucks.
for everything.
I think that is it.
Thank you very much.
I was wondering why she was so quiet lately.
So appreciate you.
Just got my message.
Thank you so much.
Yeah, that does suck.
What a bummer.
Okay, wait,
Alright.
before we go, let's see.
uh-oh, questions? Cross-examination?
You did a great job.
Oh, well, thank you. I mean, we had a good discussion, right? Everyone really had a lot to add, which helps, right?
Hey, Doc, good to see you again.
Good to see you.
Yeah, absolutely. Thank you.
Thank you for coming. Thank you for coming.
Thanks for coming and
Appreciate
participating.
the moral support.
Good questions.
I'll see you in a couple of weeks.
Hi. Thanks. Tell Sierra to put me on the stupid panel already, man. They're dragging their feet, rubber stamping.
I have to come and say hi because don't you see me? It's like, what
Of
about
course.
Sierra? Well, did Anna help you?
Of course, of course.
Yeah.
I appreciate it. Hello, Emily.
How are you?
Hey, thanks for coming.
Yeah, it's interesting.
Interesting. Oh gosh, they're so juicy. Hi. Dr. Tia. Hey, nice to meet you, Marcella. Are you at Corvell also? Yes. Nurse case manager? Well, if you like what you heard, because you might not, but if you do, I'm happy to help, right? Because these are real cases. None of them that we've worked on together, but. Yeah. Hey, thanks for all your help preparing this. Well, it's stressful. I have a 20-minute appointment. I gotta make a lot of life and death decisions, and when there's a lot of friction in it, it's scary, right? It's scary because even our non-work comp healthcare system is very dysfunctional, right? So if it doesn't get proven you work comp, when you try to take it to the personal health plan, the personal health plan will start arguing. They're like, well, actually, this is work related. And then what happens? The person's stuck without care. That's actually what happens, right? And I hope no one ever finds themselves in that situation where you, your mom, your daughter, your son is waiting for something because no one wants to pay for it. It's awful.
It is awful, all because of money.
Yeah. So I know we do the best we can here. It's cool that we have a whole community here. I've never seen it anywhere else, right? So yeah, I'm happy to look. If you got tough cases, I'm happy to help, right? If you don't, that's fine too. I'm here to stay.
All right, thank you so much.
Of course.
Nice to meet you.
Nice to meet you too. See you later.